A very good morning to you. It's a wet morning in Accra and many parts of the country. This is The Big Issue. You're welcome to your platform of incisive analysis and riveting conversation. My name is Selom Adunu. This morning, there are two key issues we are bringing to your attention, two issues that have dominated discussions this week. The first one has to do with the ambulance procurement trial. As you may know, the state or the republic is in court with the minority leader, Ato Forson, and two other gentlemen or two other persons, one being Mr. Jakpa. They are in court over what the state thinks that it lost money in the manner in which some ambulances were procured for the state. The matter has been going on for a couple of years, and just this week, the matter took a different turn. When the lawyer for accused person 1 was cross-examining accused person 3, that is Mr. Jakpa, there was a comment passed by the Attorney General, who was also in court. That comment appeared to have angered A3 or accused person 3, who went on a tangent of his own and said in the court and on record that the Attorney General had been trying strenuously in the past couple of months or days to get him to implicate and incriminate the minority leader in the discussions or in his evidence, so that the minority leader will be jailed. The Attorney General has not taken kindly to that, issued a statement denying the statement by the accused person 3. The matter is taking a life of its own, and discussions have grown. Now, we hear that there are a number of pieces of evidence in respect of meetings held between the Attorney General and this accused person 3 on what exactly we do not know. The Attorney General's office seems to be saying that those meetings were in respect of plea bargain requests or applications made to it by the accused person in question. The accused person is saying otherwise, that indeed those meetings were meant to coerce him or to convince him to give evidence that would damage the minority leader, Ato Forson. It appears to be a very murky situation still unfolding. Both sides have promised to release evidence that will put their case to rest, or their matter to rest, at least in the public sphere. It's a matter we are discussing this morning. We want to understand exactly what transpired, what the law says, and what can happen from here. The judge in question, Justice Ifia Sewabotwe, called them to her chambers. We understand they came back and apologized for the manner the lawyers conducted themselves at the bar. But that remains to be seen what happens next in court. What can happen? Is it right for the Attorney General to have engaged the accused person, or because of the circumstances of this case, that is fine? We will try and understand that from our guest who will join us. Also, the second big matter that has been ongoing for the week has been the sale, or the purported sale or prospective sale, of some 6 hotels owned by SSNIT. SSNIT says that it wants to offload 60% of its shares in those 6 hotels. Those 6 hotels include the Labadi Beach Hotel, the La Palm Royal Beach Hotel, the Trust Lodge Hotel, Elmina Beach Resort, the Busia Beach Resort, and a few others. And the person that is purchasing these hotels is Rock City. That is a legal personality. But Rock City, we know, is owned by Minister for Agric, Mr. Brian Champon. Indeed, Mr. Brian Champon has been the one speaking on behalf of Rock City in all these transactions on media everywhere. He thinks that the transaction was above board. There was nothing wrong with that. But Okujeto Ablakwa, who brought this matter to light, has petitioned Shraj, asking Shraj to investigate matters of conflict of interest and illegality and impropriety in respect of the person of Brian Champon, given that he is a politically exposed person, he is a minister of state, he is a member of parliament, and he thinks that the deal was not above board. The matters have grown, and this is what we hope to look at in more detail this morning on The Big Issue. The show is live and interactive as always. You can join us via our WhatsApp line 0204447033, and we'll be happy to read out the comments to the rest of the world. We're on Facebook as well. Kindly drop your comments at the comments section on the Facebook feed, and we'll be happy to read those comments out to the rest of the world. My name is Selom Adunu. Once again, I'll take a short break. I'll return, introduce my guests, provide you updates, and then we'll get a discussion underway. Once again, you're welcome. You're welcome back. This is The Big Issue. My name is Selom Adunu. We are live on 97.3 Citi FM. Two key issues on the table this morning. The ambulance procurement trial taking a different turn, and the court of public opinion has been engaged so much on the matters that have arisen from the last sitting of the court, where accused person 3 made some telling allegations against the Attorney General, stating that the Attorney General has been trying strenuously to get him to give evidence that will incriminate or implicate Ato Forson, minority leader, and accused person 1 in the matter. Attorney General is fought back, saying that it is not true. He only engaged accused person 3 on an application of plea bargain he brought to him and his team, and that is really what it is. The matters are growing. Both parties have promised to release evidence into the public domain, evidence of meetings. Mr. Japa, A3, says he has recordings of the meetings with the Attorney General and what was discussed. The NDC says they are in possession of that evidence, and in the coming days they will release that so we all see what it is. The Attorney General also says that they have some recordings and some audios on the meetings or on some meetings. We await to see what all of that will bring to the discussion. Now, let's, in the meantime, see what the matter really has been about the Ato Forson trial.
Richard Japa is a businessman who, according to the state, was engaged as part of the purchase of the faulty ambulances. He is standing trial for counts of causing financial loss to the state. But in his defense, Japa testified that he had no contractual engagement with the government to deliver the ambulances. According to him, his firm only acted as an agent for the main company engaged by the government for the purposes of purchasing the ambulances. During cross-examination on his testimony, however, he noted that the Attorney General had reached out to him at odd hours to seek his testimony against Dr. Ato Forson. Members of the NDC who were in court after the proceedings expressed concern about this revelation.
We as a political party are totally scandalized and disgusted by this development. We are not surprised because we've always known that this is a stock in trade of Godfred Yeboadame. This is not a man who is interested in justice or the law. This is not a man who is an Attorney General and Minister of Justice. No, this is a devious character with no honor whatsoever, no respect for justice, no respect for the rule of law, no respect for the rights of accused persons, and who always go about manipulating judicial processes to get his way at all costs. And so we are not surprised at all that today his sins have found him out.
Meanwhile, the Office of the Attorney General has been reacting to the claim.
It's very important to note that it is the third accused person who wrote to the Office of the Attorney General initiating the plea bargaining agreement or plea bargaining discussions. So if there were discussions corollary to that in respect of plea bargaining or in respect of we need or we want you to testify against the first accused person, there's nothing, absolutely nothing wrong with that. All jurisdictions do it. So there's nothing wrong with that. And we must say that there's he's not the only accused person who has approached the Attorney General in this matter. And we also have evidence to that effect. But bottom line is that according to law, something was done. And there is no scandal anywhere. There is no need for overexcitement over what has purportedly happened. The law allows it under Act 1079, which is an amendment to the Criminal Offences Procedure Act.
The case has been adjourned to next week, and Richard Japa will be expected to continue with his cross-examination in the case where he's standing trial with Minority Leader Dr. Ato Forson. Reporting for Citi News, Hansen Ajaman.
All right, so that was a short clip of what happened in court, at least not inside the courtroom, but outside the courtroom, the precincts of the court, where we heard both sides. The accused person 1, who is the minority leader side, obviously the NDC, and also the Attorney General side, that is the Republic side. And we heard lawyer Wilberforce Mensah, who speaks for the Office of the Attorney General, explaining a few things to the public after Sami Jenfi of the NDC, a lawyer himself, told the public what transpired in court. The matters are quite serious. If the matters are quite serious, whether they are proven, to be true or not. If they are right, or the matters as alleged by accused person 3, if the matters happen to be true, it's a very, very serious matter we are broaching today. To help us do the discussion will be Abraham Amaliba, who is NDC Director of Conflict Resolution. Justice Shremsai is a private legal practitioner. The Honorable Joseph Penka, who is a former Deputy Attorney General. And then Wilberforce Isaac Mensah, who is spokesperson for the Attorney General's office. Gentlemen, you are welcome to the program. I start off with you, Abraham Amaliba. You have been Director of Legal for the NDC. You are currently the Director of Conflict Resolution, still in the legal arena, and a member of the NDC legal team. What is your understanding of what transpired in court on the said day? We understand that the accused person 3, Mr. Jakpa, was being cross-examined by A1's lawyer, and how come the matters came up? I mean, just take us through what you know about what transpired in court on the said day.
Well, my understanding is that, so good morning to your viewers and listeners alike. My understanding is that there was a question that was directed at the third accused person. And when he answered the question, the Attorney General sought to say that he was in court to protect the first accused person, that's Godfrey Dame.
The first accused person, that's Ato Forson.
Ato Forson, yes. So it was at that stage that the third accused person flared up and said, look, you don't tell me that I am here to protect the first accused person. I am here to fight for my liberty. And he went extend to the next stage and said that, look, if it is anybody at all who is to defend, who is here to protect somebody, you are the one who have met me on several occasions and tried to talk me into implicating the first accused person. And that's where he started spilling the beans. And so that's how the encounter all unfolded.
So the accused person was being cross-examined by a lawyer for another accused person. At what point did the Attorney General say so? Did he rise to his feet to say so, or he just spoke at the bar? What happened?
It is difficult for me to know at what point, but when you look at the transcript, there was this statement from Attorney General which flared the accused person up. You remember the reports even indicated that at a point the judge offered him water to drink, and he said no, he wasn't going to drink water, and he wanted all that he was saying to be on record. So, but for me, what is important is that the Attorney General has met his Waterloo. In my previous position as an Attorney General, as a Director of Legal Affairs, I knew some of these things, and I heard some of these things. Court officials would approach you and tell you the shenanigans that the Attorney General is playing, particularly in cases in Asin North, and then there's one which was also at Winchi, that is the Tichema South matter. But most of the time, these people will say that, but can you protect us from being identified, that we are the ones who gave you that information? So it was always difficult to come out. In this instant, it is the person who had a contact with the Attorney General himself who decided to spill the beans. And so, if you ask me, am I surprised at the Attorney General's interference in the justice delivery system? I say no, because my previous position brought me close to some of the things he does. He simply is not fit for that office, and I have said that an Attorney General should be cool-headed. He lacks that temperament. He sees his political opponents as enemies. That's how he sees them.
No, but he has a job to defend the state.
Yeah, the job to defend the state also means that...
He has a job to ensure that wrongdoers are put behind bars or are punished.
That is so.
And that's what he's been doing.
That is so. But he's also a prosecutor who must be fair to all sides. Apart from that, he's also a minister for justice and not a minister for injustice. He should know the position he's holding. Much as your duty is to prosecute, your duty is not to, at all costs, at all costs, even if the evidence is weighing against you, to put an innocent person behind bars. That's not what an attorney general and then also a prosecutor is to do. A prosecutor success is not measured in accordance with the number of cases he has won, but it is measured in the number of cases that he has played it fair to all manner of persons within the legal system, I mean in court. So I think that at this point, Godfrey Dame should resign.
He should resign.
He should resign.
Over an allegation, just an allegation.
No, but Kame will see it. In fact, next week, we have promised to put these things out. You will hear his own voice.
His own voice trying to
you hear his own voice. A3 to implicate.
To implicate the minority leader.
Minority leader. And so, I think that it is in his best interest to resign before this evidence is adduced. Because he knows he has met the accused person several times without his lawyer. He knows he has met the accused person and spoken to the accused person in times that the accused person himself described as ungodly hours, all in an attempt to get the accused person implicate the first accused, the third accused, implicate the first accused person. It is not heard at all for an attorney general to be seen to be doing this type of shenanigans. Godfrey Dame just thinks that he must have his way when prosecuting a matter. See the case in which the Opuni case. When Yanuga left the scene and a new judge took over, the judge ruled that I need to start this case afresh because I need to observe the demeanor of the witness.
But the judge had two options. The judge could do what he did. The judge could have also gone ahead to adopt the records of proceedings. The judge decided to start the matter de novo. The Attorney General felt aggrieved, quote unquote, and so he took the matter to the next level. It was a court of appeal that reversed that decision. So it wasn't the Attorney General. The Attorney General did what any lawyer would do when you are aggrieved or your clients are aggrieved by a ruling of the court or a decision of the court. So it was the court of appeal that overturned that decision and not the Attorney General.
That's not my interest. My interest is when the judge was suddenly transferred because he took a decision that was not in the interest of the Attorney General.
But we don't know whether the transfer was based on that decision.
Every fair-minded person will know. Today, the judge is in Kumasi. We are told he doesn't even have a court to sit in.
No, he sits in court. I'm reliably informed that he sits in court. He sits in court.
So, if you have an Attorney General who conducts himself this way, so you disagree with him, he finds way by which to punish you in this particular instance. And so for me,
it will not be the first time a judge is transferred.
It's not about the transfers.
It could be coincidental. It could be that the transfer was cooking, and it just so happened that at the time this decision was made, the transfer letter came, and so he had to leave.
Now let me tell you, I was before that judge. I had a case before that judge.
In fact, I also have cases before the judge.
Yes, I had a case before that judge.
Yes.
And so the judge, if you are going to be transferred, you know about it ahead of time.
But not really. You
know about it. So you notice that when he took that decision, it didn't keep long. Just within a short period, he was transferred. And I think that it is connected to his decision to start the case de novo. And this is not the first time that we have suspected Godfrey Dame to be interfering in the justice delivery system.
I see. Let me speak to lawyer Justice Srem Shrice, a private legal practitioner. Counsel, good morning. Welcome to the program. Interesting times ahead. Of course, I know you've been following the matters of the last few days in court, etc. What's the general view about how matters have turned out?
Thank you very much, Salom, and thank you to your viewers. I think this is very, very bad for our justice, criminal justice. It's extremely bad. And it's bad in the sense that for the first time in probably my practice, I have heard an Attorney General the Office of Attorney General has issued a press statement, saying things such as people trying to influence him, and that he has those persons on video, and I'm asking myself, the Attorney General is very much aware that any person who tries to influence him in the way he is put out there, as well, is committing some crime. You understand what I'm saying? So if he finds it necessary to just issue a press statement saying these things, then clearly he's not doing his job. But that is not even the point. You see,
let me deal with this one. We live in a cultural, there's a cultural context.
That's where exactly where I'm coming to.
Okay.
That's where I'm coming to. So we live in a society where at every point in time, whichever office you occupy, someone is, one way or the other trying to influence you to have your way. If that is the general rule, then why is he pointing it out this time around? Is he ready to tell us the number of persons who have approached him on the number of cases that the Attorney General is on to bring those ones out? And this is where I said this is very bad. It is bad because what the Attorney General is trying to do is not to complain about the general issue of people trying to influence them, but to create a propaganda out there that to also overturn the impression that was created in court. And that is where the problem is. You see, if you read the statement, take paragraph 1 for instance. The Attorney General is basically saying that he could have won the case merely based on what? Documentary evidence. If you read that paragraph 1, what he's trying to say is that he has solid documents to win his case. Then the question comes, if you know you can win the case based on merely documentary evidence, which you call records, why are you now calling witnesses or trying to even cross-examine? And these things like this put the judges who sit on such cases in a very difficult situation, because then now the judge is in a fix because the Attorney General has issued a press statement telling the whole world that the case is so strong, he could have won it with documentary evidence. And then how is the judge going to feel if he rules against the Attorney General? And the Attorney General is not an ordinary lawyer. Attorney General office is a very serious and he has a very huge influence in everything that happens. So if the Attorney General, alongside the case which he is prosecuting, finds it necessary to be issuing statements, making allusion to some of these facts, and putting undue pressure on the judges and prejudicing the cases for the defense people, it's a very bad thing that has happened. Secondly, you see, this issue, a witness has come to court or an accused person is in the dock. In any case, is it wrong for an accused person to protect or seek to protect a co-accused? It is natural part of trial to, at least because depending on the nature of the trial and your understanding of what
their interests may be aligned.
Yeah, their interests may be aligned. So the first complaint against the A3 that the CK is here to protect, even is a very unfortunate incident to happen. Now A3 has come out to say that contrary to what the Attorney General is saying, it is him, the Attorney General, and this is why you see, let's be clear here. As far as the records show, the accusation is not to the Ministry of Justice. It is against the person of the Attorney General. So to issue a press statement and try to create an impression that plea bargaining is an admission of guilt. You see, let me take this opportunity to educate the public on plea bargaining so that the impression which is created in, I think, paragraph 3 or 4 of the statement, as if when a person, an accused person, applies to be considered for plea bargaining, then it means that it's admitting guilt. No. In fact, the fact that the plea bargaining didn't succeed should tell you that the accused person is not admitting his guilt. Plea bargaining is simply a new law which has come to say that, look, sometimes prosecution has so many things going on. When you enter court, some people will go for plea bargaining not because they are guilty, but because, look, our justice system has a lot of problems that we know. A simple trial, which would take maybe 3 days in another jurisdiction, can run into years. And if I'm supposed to wake up, and we also know that sometimes people are taken through this criminal justice system, not because they have done anything wrong, because someone sitting somewhere wants to show someone where power lies. So there are so many reasons why somebody will enter into what? Plea bargaining. And if the person applies for plea bargaining and the whole Attorney General, this is not even an ordinary prosecutor or anyone, the whole Office of Attorney General on the letterhead of Attorney General, who understands the essence of plea bargaining and knows very well that an application for plea bargaining is not admission of guilt, and indeed is actually without prejudice, yet was able to put on a press statement saying that in fact, it is indeed the accused person rather who was trying to get to influence him. And the evidence of this alleged influence is what? His application for plea bargaining. It didn't end there. Just after the press statement was issued, we saw copies of the plea bargaining document, application, and the correspondence between the accused person's lawyers and the AG flying in the media. Who released those things? And you could see stamps of what? Attorney General Office on them. What it tells you is that the Attorney General has no intention of actually conducting a fair prosecution. Everyone in this country knows that when things are put in the media, one way or the other, you come to the attention of a judge. And when it comes to the attention of a judge, what is the point? It is trying to what? Influence the judge and influence the public against the person, and that is unfair practice. That is unfair practice and should never even come from the Office of Attorney General. Yet, we saw this on a letterhead, we saw it out there, and the media, some media personalities are feeding on it and making it look as if I apply for plea bargaining, it means that I'm guilty. And these are some of the things that are making it very difficult to disagree with a statement which, Mr. Samoku made at the University of Ghana some time ago. He said what? The Attorney General is not Attorney General, is the Attorney General of the Republic of Ghana. He is not he's not the personal lawyer of the president, and he's not the personal lawyer of any regime. That is the character of the Attorney General. But what we see these days is as if we have a regime lawyer who persistently is trying to do things to favor a particular regime instead of what? Administering justice. And that is what I think that we should all stand and condemn. What has happened?
But Justice, his client is the Republic. And of course, I get the point that he's Minister of Justice, he must seek to be fair to everybody, which is what even lawyers, in any matter are entreated to do, must be fair to all parties. But his client is the Republic, and his client feels that it's been shortchanged. He has to push the case of his client fairly. And he would argue, and many have said that is what he is doing.
You see, most of the things that the Attorney General is doing, if you, Salom, you're a lawyer, if you did any of them, you'll be called before the General Legal Council. And you won't come out clean.
But things like what? Because
the reason why, the General Legal Council doesn't have jurisdiction over Attorney General. The Attorney General doesn't take a license. The Attorney General is appointed, is a constitutional creation, and General Legal Council is a statutory body. So you cannot, it is even important, Attorney General is appointed not just by the President, by the board, approved by Parliament. Is constitutional bodies that appoint Attorney General. And because of that, the Attorney General doesn't take a license, it's not amenable to a lot of the rules that bind you and I, and it's just, so what it tells you is that to whom much is given, much is expected. You are the lawyer for the Republic. Who is the Republic? The Republic is not the political party which is currently in government. The Republic is not the president. The Republic is all of us. So when Mr. Samoku Jeju said that Attorney General is Attorney General of the Republic, of the whole country, what it means, and not the personal lawyer of any particular interest or regime, what he meant in that statement is that if you are an Attorney General, the way you conduct yourself must be entirely different from how a private person like you and I would conduct ourselves. And that is why we have a General Legal Council which issues some of us licenses and regulates how we behave and regulates our behaviors and make sure that we all fall in line. But that regime doesn't apply to the Attorney General. Why? So, and I think that there is no way I will be convinced that what is happening, and I pity the judges who sit on some of these cases. I don't envy them at all. Do you know why? Because now these judges are going to find themselves, instead of looking at what is before them in court, they have been inundated by things flying in the media and commentaries to the extent that it becomes impossible for them to, or well, not impossible, but very difficult for them to do what is fair and what is just.
I see.
And it shouldn't come from, these things shouldn't come from, such a high office as the Office of Attorney General.
I see. Let me take your thoughts on this. There's an application for plea bargaining. And so the discussion had commenced between the parties, as in the Republic and the accused person 3. Let's even assume that the Attorney General spoke to the accused person 3. Would anything have been wrong with the Attorney General engaging with accused person 3?
There is a rule. You can engage with any party who is involved in the case, but you have to engage the person in the presence of his lawyer, through his lawyer. But what transpired in court didn't seem as if it was any official engagement, because the person said at all hours, you have personally contacted me. So there is nothing wrong with engaging, and we all know this. We all engage our parties on the other side, but you cannot go jump over a person's, in a criminal case, an accused person's lawyer, and then be communicating directly with the accused person. In fact, if the accused person did such a thing and is on bail, do you know it's a reason for revocation of the bail? What he's trying to do is to influence the trial and to prejudice or do things that will affect the evidence being gathered for the trial. If the accused person will be jailed for that or will be denied bail on those grounds, why should the Attorney General be allowed to do it without any consequence? And you see, some of these things, when they happen, the third one, which is even shocking and extremely shocking. Look, Solomon, if you look at the last paragraph of the letter said they have a recording of the A1, they have a video recording of A1 trying to influence the Attorney General. We all know the legal regime on secret recordings, okay? There have been a couple of Supreme Court cases on that. The exception to that, but what is the Attorney General using the video for? This would have been entirely different if he started a prosecution based on the fact that he was being influenced by the honorable minister who is being, the former honorable minister who is being prosecuted. But what is he using it for? He's using it for propaganda purposes by putting in the press statement that he has a video recording of the person doing that. What this means is that the Attorney General intends to influence, you see, he's creating in the mind of the judge and the public that these people are guilty people who are pursuing me for me to bend the rules in their favor. Is that fair? I want to answer, is that fair?
No, I get the point. I'm sure the public is following. The other point really is, we all know this in practice, where there's the issue about prosecution witness. The Republic may decide, based on one or two considerations, to use an accused person as a prosecution witness, And given that there are discussions of plea bargain, etc., assuming without admitting that was what the Attorney General was seeking to do, to use A3 as a prosecution witness, would anything have been wrong with it?
Yeah, he's entitled to do that, but it depends on the stage of the trial. You cannot do it while the trial is going on. When you have charged the person and you have the person has pleaded not guilty, trials going on, you are going to approach him and say that at this point, I want you to turn and come and support me.
No, we don't know at what point those discussions were held. We don't know at what point.
Whichever point it was held, it was clearly held without the lawyer of the accused person. Because follow the Attorney General's letter and the document they released into the media. They have a date there. And from that evidence. And my point is that even if you want to do something, there shouldn't be any situation where a lawyer will be communicating directly with a client on the other side. Even in civil cases, it is often frowned upon. Let alone in criminal trial, that was it the Attorney General himself who was prosecuting the case? I want to find out.
Yes, I understand Attorney General himself was in court.
So he himself is prosecuting the case.
Yes, he was in court himself.
Yeah, he would jump over the lawyer on the other side and be dealing directly with the accused person. Is it fair? I mean, I just want you to answer this question. What all the things that have happened, is it fair?
The AG's office has also said that they have records of calls initiated by this gentleman to the Attorney General, so it doesn't appear as if it's a one-way traffic. It's always the Attorney General who is calling.
That the AG was not the one who said this first. You see, look, when you have a problem with me and you don't raise it, and you wait for me to raise my problem, and then you are now bringing yours, what does it tell you? The AG is, look, the accused person is not a lawyer. He probably, all the things we are discussing about the rules of ethics and fair play, and he probably is not aware. So even if he initiates a call to the Attorney General, it is the duty of the Attorney General to tell him that, young man, don't call me again. This is the rules of the game. But you don't tell me that you have sat down, you have engaged this person. Now the person is accusing you of trying to turn him against his own position and his own interest. And then you are now coming, oh, don't worry, I even have this record of you and this record of you. Is it the case that if the Attorney General brings call records, would it be that it's only the accused person who was calling the Attorney General? Or the Attorney General was also calling?
I see. Quite interesting. Quite interesting. Do you think that, of course, you've said that in some other form, but what effect do you think the current happenings, now starting from the courtroom and getting expanded outside with evidence now not to be presented to the court, but evidence to be presented by political actors, etc. How do you think this will affect this case, if it has any effect at all?
Yeah, so the first thing that I'm concerned about is the judge. If I were the judge, I would be very, very, very frustrated with the current happenings. I know the judge involved is a very, very experienced judge. As she has really been one of the outstanding, judges we have. But even for such persons, when such things are flying in the media, they are overwhelmed and it may prejudice their views. And that is why, first of all, there's no rule. The rule says that don't do such a thing. Secondly, even if the judge is strong and is very, fair in everything, is able to resist the temptation to be swayed by these things, how about the accused person? Would he feel that I've been treated fairly? Should the case go against him? Would he feel that I have had a fair trial? And that is a very important element in justice delivery. They say, well, justice must not just be done, it must be manifestly seen to be done. What it means is that justice itself is people's view of what has happened. So even if I know I'm guilty, let's say even if I'm accused and I know I did what they have done to me, and the trial takes this turn where confidential document that are without prejudice, plea bargaining, discussions have been released by no mere person, by the Attorney General, to the public and to political activists to be spreading on social media. If I'm convicted, the question is, would I think that the trial is fair? That is the second one. Now, the general public, what would the general public feel if at the end of this, the accused person is discharged or acquitted? They will say, the judge has probably gone for some whatever and is now giving judgment, because in their mind, they are looking at a very powerful lawyer, Attorney General, releasing this document which for them, they understood to mean the guy had even admitted guilt and was trying to beg for mercy. But that is exactly what plea bargaining is not. You see, so if you put all this together, then you can hardly see any fairness in this, regardless of the outcome of the case. Some way, somehow, the desire to feel that the trial has not been fair, the trial has been prejudiced, is very high, and it's a very terrible thing. That is why I started my speech by saying that, look, this is very bad. It's at all-time low of whatever we have been having in this country as far as criminal justice is concerned.
I see. Can you hang in there for me? But hang in there for me for a few minutes. Honorable Amaliba, we are proceeding as if everything the gentleman has said is true. Like I started by saying, two things. It could be true, he could be peddling falsehood, and that we shouldn't put that beyond any accused person. Are we not in a haste to hang the Attorney General based on a mere allegation, albeit made in court by an accused person, and proceeding as if what the accused person has said is gospel truth?
The fact that Attorney General, who was in court on Thursday himself, did not protest, because the records do not show that the Attorney General had objected to some of the things that he said. No, but how was it to do that? Oh, but why? He's an officer of the court. Yeah, but that may not be on record. No, it will be. He's an officer of the court. He's part of the prosecution. He's actually conducting the case. And if his image has been brought into dispute in court, he has every right to...
We understand they went to the judge's chamber. We don't know what they went to.
No, but it was an open court that he made those
statements. But the judge called them out. The judge called them into her chamber. I understand. I wasn't there.
Yes, but there's but we have seen some of the record of proceedings, transcript, and there was no objection. Apart from that, it is, if you are put in that witness box, even as a lawyer, the whole court looks heavy on you. For an accused person to make those statements regarding the Attorney General's attempt to influence him to implicate the first accused person in itself is a daunting task. No accused person would go into that witness box and make such a huge statement. He followed up by saying that I have evidence and I'll provide it.
Yes, but you don't put it beyond any accused person. To say it to be difficult for an accused person say all manner of things. This is somebody who is getting almost to the end of a trial. Maybe seeing his evidence and what is against him, he thinks he may not be able to come out clean.
Accused persons will lie in the course of the trial, matters relating to the hearing, but not an accused person lying in respect of an attorney general's conduct. That's not what we talk about. I know people can swear the oath, and once they enter in there, they lie. My house number is D44. Then they say my house number is D5. Those things are common. But an accused person goes into the witness box and knowing the might of the attorney general, but will look into the face of the attorney general and tell the attorney general, you are the one who approached me to do that unspeakable act. No, it's difficult for that. But,
let me, okay, just conclude here.
The attorney general, and I told you that he has the penchant for that. I have indicated to you that in my previous position as the legal director of legal affairs, I have come into contact with the conduct of the attorney general when in prosecuting cases. And so this does not come to me as a surprise. He says that the accused person called him and that there are records of that. I'm happy Justice Sai has indicated that what an attorney general should do is to stop the accused person. So how do you then use that as evidence? How does that help your case? How does that, you saying that accused person have been calling you, help your case in this? It means that you yourself, you are so
lackadaisical. Accused person may be calling him, but he doesn't encourage it. We are not told.
We are not told. What he has said that there's evidence to show that accused person also calls him.
But we don't know what he told him. Just hang it there. Let me speak to the Office of the Attorney General. Spokesperson for the Office of the Attorney General, Isaac Wilberforce-Mensah, joins us. Isaac, welcome to the program. This must be a very busy time for you and your office. But what's the mood in the Attorney General's office as we speak? Hello, Wilberforce. I don't have Wilberforce. We'll try and re-establish connection with him. Abraham, you're making a point about the seriousness of the Attorney General saying that he got calls.
Exactly. It goes to his credibility. Now, if an Attorney General comes out in his defense of this matter and says that, oh, but you two have been calling me.
Sorry, Wilberforce is back, so just note your thoughts down. Wilberforce, I was trying to find, welcome to the program. Wilberforce speaks for, he's a state attorney or an assistant state attorney, and he speaks for the Office of the Attorney General. Wilberforce, welcome to the program. I wanted to find out from you what the mood in the office is in respect of this matter.
The mood in the office is business as usual. Everyone, good morning to your guests. And in fact, everybody you have on your panel this morning are really good friends of mine. So good morning to them and good morning to all Ghanaians listening worldwide. Now, the mood in the office is business as usual, because the focus of the office is defending the Republic and instituting or initiating cases at the instance of the Republic, and in this particular matter, the criminal matter going on, the prosecution of Mr. Richard Jakpa and the Honorable Ato Forson currently ongoing on in court. So there's really nothing new happening at the office. The issues concerning Mr. Richard Jakpa's statement, I think is very important for us to put what was said in court in context, because the spin that has been given to it was only given to it, or the statements that he's alleged to have made were made through the mouth of another good friend of mine, the Director for Communications for the NDC, Sami Jemfi. What Mr. Jakpa is quoted as saying in court is that the AG has on several occasions engaged me at odd hours to help him make a case against A1. Is this allowed in law? Yes. And I have evidence of that. If he pushes me, I will open the Pandora's box. He goes on to say that I don't understand why the AG will accuse me of defending A1 when I'm here to defend myself. If he pushes me, I open the Pandora. At which point in this quote did Mr. Richard Jakpa say that the Attorney General has asked me to fabricate evidence against A1? At which point in Mr. Jakpa's quote, as has been reported by the court, did he say the AG has asked me to falsify evidence against A1? So if what Mr. Jakpa said is allowed in law, that you can use one accused person as a prosecution witness or to testify against another accused person, if this is allowed in law, what exactly was the AG supposed to object to? Nobody has accused him of fabricating evidence in open court. What was said in open court was that you have asked me to, and I quote again what Mr. Jakpa said, you've engaged me at odd hours to help him make a case against A1. Now let's look at this conversation of odd hours. He said he will come with proof. He says he has recordings. We have asked that, yes, bring the recording. We are open to it. And a few days ago, the Director for Communications, once again, Sami Jemfi, did mention that the meeting was not between the two parties alone. It was with a Supreme Court judge involved, or a Superior Court judge involved. And I'm telling you at this point, so that issue of clandestine meeting is obviously taken out of the equation, especially if we are able to show that this third party, this Superior Court judge, or this meeting was at the instance of the accused person. So then the whole issue of...
So that will be just one instance. But I have the transcript also. It's my lady, I've heard that, but okay, I want to make it clear that the Attorney General has on several occasions had meetings with me privately at odd hours, both in person and on phone, in respect of this case. And that's it, to cooperate or answer questions in a manner that will make his case better against A1. And I have refused, and I have evidenced to that. And so if he is accusing me here, I'm here to defend A1. He has brought hostilities to my doorstep. That's what he's saying.
Absolutely.
Yes. So he's alleging.
There's no allegation of.
No, he's alleging that it's not just one. It's not one meeting. He's alleging that it's not one meeting.
Nobody has said it's one meeting. But what we are saying is that all these meetings which are permitted in law were at the instance of the third accused person.
Without his lawyers.
These meetings were held in the presence of a third party at the instance of the third accused person.
Yeah, so is it a case that I will take a break. I'll take a break, but I need you to think about a few things so that when we come back from the break, you answer those. Were all the meetings he alleges, did all those meetings take place in the presence of that third party? And of course, Justice Shremsrai and Amaliba here have raised issues about why the meetings will be held in the absence of the person's lawyer. Try and clear that up for us when we come back after the break. This is the big issue on 97.3 Citi FM. We're discussing the matter of the ambulance procurement trial and the matters that have arisen therefrom in respect of accused person 3 saying that the Attorney General tried to get him to implicate or incriminate accused person 1, minority leader, so his case is better than his, so he gets him caged, more or less. So that's what we are looking at. We'll take a short break. When we return, we have the Attorney General's office's spokesperson, who is also a lawyer, on the line, and Justice Shremsrai, a private legal practitioner, is on, and then Amaliba Abraham, who is of the NDC's head of conflict resolution, and we'll be joined by Deputy Attorney General as well, former Deputy Attorney General Joseph Kwenka, to bring the discussion home. Don't go away. Before we took the break, Wilberforce, Isaac Wilberforce Mensah was on the floor explaining to us what the matters are from the view of the Office of the Attorney General. So, Isaac, once again, welcome to the program. So, we're trying to find out, whether the third person you mentioned that was in that meeting alleged by Mr. Jakpa A3, that third person was in all the meetings, because he said there were several meetings and some were on phone And those ones on phone, was it that the third person in question was joined by a conference, or it was just a meeting between the two? I mean, just clarify that for us.
The actual meetings were held with the third person. The third person was, in fact, this third person is the Supreme Court judge. And it was at the instance of the third accused person that these meetings were had. And all the phone calls were follow-ups to that meeting that was had. So now in respect of this, I think I'll use this opportunity to address the question of, or the statement of, dealing with the accused person and not the lawyer.
Yeah, but before that, yes, you mentioned a Supreme Court judge. I think now the interest is which Supreme Court judge was that, and what really was his interest in meeting the Attorney General and the accused person? Who is the Supreme Court judge, and what was his interest?
If I say that, no, we are not here to throw names, or the focus, I'm telling you, the focus of the office is on prosecution. We are not going to be swayed by diversionary tactics amongst others. The Attorney General is resolute in his mandate and Article 88. Now, with the issue of the Supreme Court judge, what I can say for now, what I will say for now, is that it was at the instance of the third accused person, and it was obviously to negotiate a plea agreement in that regard. So this is really much ado about nothing. Everything that was done according to the books. And speaking of the books, maybe I should just go to the books, because some statements have been made that it wasn't with his lawyer. And this same lawyer, after they went to the judge's chambers and they came back out, this same lawyer came to apologize to the Honorable Attorney General. If it was a conduct that was offensive to the lawyer, should it not be the Honorable Attorney General apologizing to the lawyer for the third accused person? That's not what happened. What actually happened in court is that the lawyer came out to apologize to the Honorable Attorney General. So, I don't know, Salom, if we can go straight to, because time is, I don't want to not say some things, then time is up, and then, the narrative will still be misconstrued or changed in a certain way in the public light. So what the public need to know, for those who do not know, and my colleagues there are all lawyers, they are seasoned lawyers, and they know that these things are allowed. They are aware of Act 1079. They are aware that according to Act 1079, you can deal with the accused person. According to Act 1079, you need not deal with the accused person's lawyer. You can deal with the accused person. And in this case, it was at the instance of the accused person that these meetings were had. What they jumped to is Rule 13 of LI 2423. Now, they are also aware that the LI cannot be superior to an act of parliament. They are aware that, let me just read what the law says in respect, or what an actual act of parliament says in respect of this particular matter, and not what the LI is saying. Now, if you look at 162, I'm talking about the Criminal and Other Offences Procedure Amendment Act 2022, Act 1079. If you look at 162, for instance, 162A says, subject to 162B, a person charged with a criminal offence may, at any point of that before judgment. Now let's look at 162C. So this is to say that plea negotiations can happen at any time before judgment. And I have heard Martin Pebu, for instance, say that once a plea negotiation commences, you have 30 days, and after 30 days, the plea negotiation is there. That's not what the law says. What the law says is that after 30 days, a court may continue proceedings. It does not say that plea negotiations have ended. Now, 162C says that the plea negotiations referred to in section 162A may be initiated by an accused person or counsel for the accused person. Now, this is disjunctive, not conjunctive. An accused person, or so the primary focus is even on the accused person. So if there's been any such negotiation with the accused person, at the instance of the accused person, at a meeting with a third party involved, and this third party, the Superior Court judge, who was there at the instance of the accused person or on behalf of the accused person, how then do you then turn around to say that these are odd meetings at clandestine places or any such things that were not even said by the third accused person, Richard Jakpa himself in court? These statements...
Isaac, I hear you, but I'm looking at the 162C as well. It said the plea negotiations referred to in 162A may be initiated by an accused person or counsel for the accused person. We know that in criminal trials, it's not every time an accused person comes with a lawyer. So if the accused person does not have a lawyer, maybe he could initiate this, as the thing is. But we've seen letters also put out by your office, I'm sure, about the accused person's lawyer seeking to initiate that plea bargain arrangement. From all the letters we saw, it did appear that your office rejected the offers they were making because your office thought that the offers were not good enough, which is fine. So there was surely and certainly a lawyer in the mix, you know. So I don't know whether to call it best practice or not, but given the sensitive nature of this case and all of that, don't you think, even without the law, that it was proper or it would have been sounder to have involved his lawyer in those discussions? If that had been done, I'm not sure we would have been having this discussion today.
The law here in 162C does not say that where the accused person is represented by a lawyer, you meet with a lawyer. No. That's not what passing. Let's not import interpretations where the law is abundantly clear. It's clear on the face of it that you can have these negotiations with an accused person or the lawyer. And it's also instructive to note. It's instructive to note that this accused person was, or these meetings were at the instance of this accused person. This accused person could have invited his lawyer, could he not? So if there's any impropriety here, then the impropriety should be is on the part of the third accused person. Because if the law allows it and is in plainly worded English here, I don't see why we should import fanciful interpretations to this particular thing. And also where the lawyer himself, after what took place in court, came out to apologize, one can even infer that the lawyer is even aware of all these things already. Nothing under law stops an accused person from negotiating or initiating plea discussions or negotiations with the prosecution. There's nothing untoward about what went on.
Very well. Let's go there. You come back. Let me deal with it. Say the accused person, the lawyer for the accused person came to apologize. I wasn't in court. You were in court. And from the transcript I have, the court or the judge said that, please, Mr. Jakpa, all the fight they were fighting and disgracing the bench and the bar, I did not write it. Please move on. So I don't know if the apology was in respect of the fact that the Attorney General is the leader of the bar, and so a lawyer should not be seen engaging him in a certain manner, which the judge says was disrespectful to the bench and the bar, etc. And so that apology was rendered. Or the apology was based on the substance of the matters before the court on that particular day, as in the allegation made by Mr. Jakpa, etc., against the Attorney General. Yeah. I wasn't in court. So if you can clarify for us what that apology was about, I'll be grateful.
The apology was in respect of what happened in chambers. What the discussions that went on in chambers, which of course, if it was for public consumption, they would have done so in open court.
Sure.
So the apology was in respect of that, and I can say that on authority. So you cannot say that the lawyer was unaware of such meetings or such discussions, especially when these meetings were not meetings that were meant to favor prosecution. Prosecution had already closed the case. Prosecution has submitted documents to prove their case. And then after prosecution has closed the case and a prima facie case has been established by the court, and defense or the accused persons have been asked to open their defense, it is now that these plea approaches were made to prosecution. So there's absolutely nothing wrong that has gone on here. Prosecution did not, and that's what the Honorable Attorney General stated in his letter. Prosecution did not approach the third accused person. It is the third accused person who approached prosecution. And if negotiations were made or were had corollary to this particular approach or initiation of plea negotiations, there's absolutely nothing wrong that has gone on here. And counsel, no.
I see. That's quite interesting. Let me speak to Shremstra. I'll come to you. Justice Shremstra, if you're still there, the Office of the Attorney General is of the view that, given that the meeting was initiated by the accused person in question, and there was a third person, now we are hearing that it's a Supreme Court judge, the third person involved, there was really no need by the law to have the accused person's lawyer in that meeting. And so the whole talk about the lawyer being in the meeting, etc., it's irrelevant to the discussion.
Thank you very much. You know, there's a rule that if you are a lawyer and you are engaging a client, you should write your terms down in terms of contract, right? So if you're a lawyer and you choose to exercise your discretion, that I contract may be verbal or written or unwritten. So I'll choose the unwritten form of contract. And there's a dispute between you and the client. You know, what's the position of the law? The position of the law is that you, the lawyer, will be what? You'll be the loser, because you know what the law says. The client doesn't know what the law says. I am surprised that a lawyer will write a letter to the Attorney General showing interest in what? Plea bargaining. And then when it's time for the plea bargaining itself, the lawyer will stand aside and the Attorney General will watch on for the accused person to come. And you see, Solomon, I'm really embarrassed by this conversation. And I'll tell you why. You see that a Supreme Court judge's name has come up in this issue. Why should this be? Why should it happen so? Are you sure, Wilberforce, are you sure you have sought the consent of the Supreme Court judge who's involved on this, that this information should be let out? You see, we live in a very, communal society where a lot of things happen informally. But I think that when things like this happen, it is the duty of those of us who are lawyers and who know the privacy matters and all the things that are involved in the work we do. It is our duty to be sure that we do not, do things like this. Unfortunately, we are here and it's even getting worse, because my initial concern was the fact that these matters of plea bargaining are without prejudice and are not matters that are supposed to be out there. And I had a problem when the Attorney General put those matters on a letter and released to the media some of the documents involved in this. I was thinking that there would be a general acceptance that there was an error from the Attorney General office, even with those kind of things. Now we have a situation where even more scary things are coming out in respect of what? A Supreme Court judge. Yes, I can understand why a Supreme Court judge on a very social level would like to make some things, but it doesn't sound right. And I think the Supreme Court judge will not be happy with a situation where he is sitting at the apex court, there's a trial going on, and he would be announced publicly as involved in what? Negotiation, in what capacity, no one knows. And that is why I'm embarrassed by this conversation. And at a point, I wanted to log out because, to be honest with you, I don't think that is a proper thing to do, to be coming out with some of these things on the media or in any place of conversation like this. And I think that the AG, I will plead that whatever is going on with the Attorney General, the way the Attorney General's office is going about this, it's even given an impression that the guy, A3, is that him, Mr. Japa?
Yes.
Had a strong, what he was saying probably is true, because the reaction is just shocking and overwhelming that to this point, we are even mentioning some of these things, which I am not particularly happy about. And I pray that maybe that Office of the Attorney General should rather cut it at this point and not extend this conversation to.
Yeah, but Justice, I'm not sure the Attorney General is disputed the fact that there was some discussion. There was a discussion. But my understanding is that discussion was geared towards using Mr. Japa as a prosecution witness. We don't know at what stage of the trial, whether before they were charged or not. I don't know at what stage these discussions took place. So yes, there could have been a meeting, but the purpose of the meeting or the substance or objective of the meeting may be different from how it is being put out now. Do you get that sense?
I get the point. And you see, that is why I made some, I illustrated lawyer clients, engagement letters and all that. Now you have the accused person saying that you were trying to, force him to give false testimony or to do something which is not right. That is what the accused person has said in court. Now you are saying that that is not the case. And that is exactly why you should involve a lawyer from the accused person, because you see, accused person is not a lawyer. You see, I think this is basic. I don't see why we can even sit down here and argue that a lawyer has written to commence plea bargaining conversation, and somewhere along the line, it is good practice, or it is even lawful or proper, ethical for the lawyer to be pushed aside and to have the client, the accused person, have a direct conversation. And well, here we are. Maybe it is good, maybe it's not good, but at the end of the day, it is exactly why exactly because of this, your word against my word, and your misunderstanding of what is happening against the Attorney General's understanding. That is why you need a lawyer for the accused person. If you have exercised your so-called discretion, which I think that it's not even a discretion in this case, if you have exercised it and the consequences are here, this is not your response to that. Should not be to expose or to try to bring in more, questionable things like a Supreme Court judge coming to be part of some negotiation in what capacity, no more. I don't think that is all these things. This is not right. Let's just agree that some things are just not right, and we shouldn't do them.
I see, but just to also point out that, of course, this will not be the first or last time a Superior Court judge is engaged in a negotiation of a kind. They help solve, they help resolve issues.
Don't misunderstand me.
Okay.
Don't misunderstand me. My point is this: is the Supreme Court judge, has he given his consent for these things to be out?
No, but he's not been named. We don't know who he is.
You ask these questions. You ask that in what capacity was the Supreme Court judge doing it? All these are questions that will come up. And I don't think that when you go for pre-trial settlement or these things like this, you have in mind a situation where all these things will come out. So from a professional point of view, as a lawyer, I think there is a lot of question on these things. And even if if the Supreme Court judge has given his consent or whatever, this still doesn't sound well. That is all I'm saying.
Very well.
I'm not saying that it didn't happen. Neither am I saying that it should have happened, whatever. I'm just saying that, look, I know these things happen. All manner of people are sometimes involved in some of these settlements, some of this discussion and all that. But it is not something that I think those people who get themselves involved in this who want to be out. It's not that it is wrong, but we are using these facts to create a different impression. So there's a difference between what has happened and what the Attorney General is using what has happened for. So if you have a conversation with someone, okay, Shalom, and the person is asking for, please, can you cut down on this thing? Can we change it? We are having a prosecution and I'm having those conversations. Those are things that everybody will probably do, but are you going to use them as a tool for what? What is happening? Is it what is supposed to be done? That is the question here.
Very well. So I will ask you finally. Wilberforce, you come in. Wilberforce, I'm coming to you actually. So I've been thinking about what the way forward will be as your concluding comments on this discussion. I know you have to go, but do that for us. So Wilberforce, yes, you said you have something. You obviously have something to say.
I think I 100% agree with Justice Shrimsai. It's very horrible to have brought in the issue of the Supreme Court judge or Superior Court judge. It's very horrible, very distasteful, very disgusting to say the least. But this was already out there. This was not put out there by the prosecution. On 23rd May 2024, this information was put out there by the Director for Communications for the NDC, Sami Jemfi. So it was not the Attorney General who put out the information about the involvement of the Superior Court judge or the Supreme Court judge. Remember that this sort of makes the case of the Attorney General better. But the Attorney General maintained his responsibility not to disclose such information because the involvement of this person was at the instance of the third accused person. So the Attorney General was very tight-lipped about this. You did not find a reflection of this even in his statement. On the night of 23rd May 2024, on Joy, that was when Sami Jemfi brought in the issue of the Superior Court judge. So I agree with you, Justice Sai, on that point.
Yes. So Isaac, upon hindsight, yes, do you think that the prosecution, maybe the Attorney General, should have involved a lawyer, even though you say the law is clear that
if you look at, for instance, the same section, Rule 13 of LI 2423 that they refer to, if you look at 13.2, For instance, it recognizes that these rules are subject to law. It says here that a lawyer shall not, in the course of representing a client, communicate the subject of the representation to a person that the lawyer knows to be represented by any other lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law. Now, 1079 by law authorizes you to deal with the accused person direct. So yes, he was authorized to do so by law, and that's exactly what happened. So has anything unlawful been done? Absolutely not. With the greatest respect, absolutely not.
Very well.
The focus. Before I conclude, the focus of I believe the NDC should be how to defend this particular matter. All these things going out of court do not touch on the elements of the offense as has been established, or at least the prima facie case that has been established according to the court. Not to sound sub judice, but according to the court, a prima facie case has already been established, and that ought to be the focus of the defense, and not these things that are evidently lawful. So the recording is only coming to show that a communication was, and this has not been denied. Yes, there was such a communication, but the communication was not to fabricate evidence. And the issue of perjury, I think Justice Srimsai, I think you should maybe talk to Sami Jemfi to remove the discussions of perjury that he's talking about in the media, because an accused person cannot perjure himself. The Constitution protects you from perjury. Perjury applies when you are sort of making false statements for another person to be incarcerated or to be found guilty. So that other person ought to be on trial. If you are on trial, you cannot perjure yourself. So that communication going on, that he made a statement on oath at the risk of perjury, please, I think that aspect especially should cease as well.
Franklin Kujo is in the discussion. The lawyers have spoken.
No, there's a legal matter. He's running with it, and I need to correct it. The issue about Section 162C
of the Plea Bargain Act.
When you read that portion, there's a key word there. Initiate. If you find it.
Yes.
If you find it, you read it out. Initiate. Where they say that the accused person or his lawyer may initiate.
Yes.
What does initiate means?
To
begin a process. How about the subsequent meetings? Do you do it without his lawyer? Do you do it without his lawyer? And you want to persist in that and say that the key word there is initiate. To reach out, to start a process. But the provision also takes care of what you initially said. That look, there are some accused persons who don't have lawyers. So it makes room for the accused person himself to initiate the process and maybe even continue. If Jakpa didn't have a lawyer, the subsequent calling and all those things would have been will sit well with this provision. But he has a lawyer. And so if you say it means that the accused person can have those discussions, it's wrong. Initiate doesn't mean to continue having the discussions. That's what he should know. Secondly, to the judge, what role was the judge playing? And he's seeking to use that to make as if that makes their case better. That because it was before a third-party judge, a Supreme Court judge, it means that it was okay. So the judge, that Supreme Court judge, okayed the process of dealing with the third accused person without his lawyer. The Supreme Court judge didn't see anything wrong with that. Or the Supreme Court judge was now playing the role of a lawyer for the third accused person. So there are more questions, and the more he goes on that tangent, the more it raises a lot of questions about their own conduct. It doesn't help their case.
Very well. So let's take it from the arena of law, and let's speak to Franklin Kujo, who is more or less an ordinary member of society and a civil society avatar.
And a street lawyer.
Okay, I hear a street lawyer to Franklin. So, Franklin, listening to all of this and following the discussion in the media and from the various actors, where does your mind take you?
Well, good morning, everybody. I'm a bit ambivalent, especially on this issue. I mean, the Attorney General is not my favorite person. Everybody knows that. I think he's Attorney Generals during the military eras are even better. I think, but on this one, I'm willing to give him the benefit of the doubt, because clearly speaking, For me, I think there's entirely nothing wrong if a party decides that they wanted to see, the prosecution or the opposing lawyer, essentially to say they want to settle something of that nature. I'm not going to use legal term, but I'll just say probably just have some bargaining and then have some reduced sentencing and all of that. The only bit that I'm a bit worried about is when Jakwa is claiming that he was asked to deliberately deliberately implicate Ato Forson. It's a bit that we have to get to the bottom of it.
But the claims
in terms
about
of-
falsifying, fabricating, etc., were not his words. His words I have here are, I want to make it clear here, the Attorney General has on several occasions had meetings with me privately at odd hours, both in person and on phone, in respect of this case, to cooperate or answer questions in a manner that will make his case better against A1, who is Ato Forson. And I have refused, and I have evidence to that. And so if he's accusing me here that I'm here to defend, so that's it. So the issue about falsifying,
but it's
fabricating.
it's actually the same thing. It's the same
No, but
thing.
words are heavy. So
It's
falsify,
essentially to say that
fabricate.
they are preparing. It's essentially trying to say that cooperate, get this guy nailed, so that probably you get something in exchange. I mean, it's clear.
But that's
And I see
that's what generally prosecution witnesses do.
I understand that, but that's what I'm saying, that it's a bit of a subterfuge, because in this case, this is a political case. Let's not quibble over it. I mean, I've gone through the time. I've seen all the conversations around this particular ambulance matter, and frankly, I feel the Attorney General is overdoing it. I think this is so political, and the reasons why that's why people on the other side will believe everything that what's called Jakba has said, and may even go further to say the AG was engaged in some sort of an exchange for treachery. I don't think he was doing that. I think he wanted some information. We need to hear his side as well. But as I said, I think this case should not have traveled the length of which it's traveled. But anyway, you have a very vindictive AG and a vindictive government that is bent on making sure that certain persons, even if they are getting some sort of fair hearing, are actually prosecuted. Look at the Opuni thing. It's become a joke. I mean, I don't understand what is happening to justice delivery in this country under current circumstances. And I really shudder to think that we are in a certain modern country supervised and governed by a human rights lawyer, my own friend Nanado, whom I do not want to be hearing from again until he leaves power. I don't understand what is happening here. So frankly speaking, I have made a point clearly from day one that this is a politically, it's like political vendetta. This guy must be jailed by any means. So, well, they may have to deal with what is coming out of this, but I still insist. I don't think the Attorney General may do many things, but I doubt he really wanted to. I really doubt that.
I see. So let me take your concluding remark on this, Justice Remsrai. So where do we go from here? How do we come out of this clean, and how do we ensure that justice is served and justice will be manifestly seen as served? Okay, I think it's gone off. So let me come to you, Amaliba. How do we come out of this as a people convinced that justice really has been served? Because this takes the matter from the substance, itself we are prosecuting in court, and we've thrown it by some means into the air, and now other considerations have been read into it. How do we navigate our way out of this?
To answer your question, it is clear that the Attorney General's conduct has brought about all this. And for me, if the Attorney General fails in his attempt to extricate himself from this quagmire in which we find ourselves, it will be difficult for people to have confidence in the prosecution. We are overemphasizing the meeting that the Attorney General had with the accused person. But for me, the emphasis should be on the content of the meeting. It's not just about the meeting. If the contents of the meeting suggest that there's some conspiracy to have A1 jailed, then that for me is the key issue. After meeting, you can meet for good purposes. But when you meet for the wrong purpose, that is where the emphasis should be. So the Attorney General saying that there's nothing wrong with meeting the accused person, but what did you say to the accused person? Is it what the accused person is telling us in court that you told him that help me to incarcerate the A1? If that is it, then the Attorney General has misconducted himself. The way forward for me is to lay bare all the evidence. I think that if the NDC next week puts out the evidence and then Jakpa also goes back to court, I think on Tuesday or Thursday next week, also puts out the evidence and they are incriminating of the Attorney General must resign, must step aside.
So you initially said that the Attorney General should resign now, but you're not saying that the resignation should come after the...
I am telling you he should resign because I know that they are damning. And if he were in other jurisdictions with these issues embroiled in his face, I think that in some jurisdictions the Attorney General will have resigned. Because I know what is coming. I have heard his voice. Unless he wants to come back and say that that's not his voice. But if the evidence are put out there and it is clear to the entire Ghanaian population that these were the things that the Attorney General has done, if he's not going to resign before the evidence is shown, then he should do the needful by resigning and allow the Deputy Attorney General to continue with the prosecution. That for me will bring about sanity in the prosecution of these persons in court.
I see. Wilberforce, concluding remarks. How is the Attorney General going to navigate his way out of this?
The Attorney General, I have always maintained, is focused on his work and his mandate under Article 88 of the Constitution. The Attorney General has submitted to the court or has tendered into court exhibits upon exhibits, documents that were in the public service. These were not documents that were fabricated, the word that is being put out there. These were not documents that were falsified. And based on these documents, the court has agreed that the Attorney General has established a case and the accused persons have a case to answer. So this issue of what happened several years later of meetings with one of the accused person or communication with one of the accused person, which I have already established that there's nothing unlawful about that. Rule 13 is subject to an act of parliament, Rule 13, which was made by the General Legal Counsel and the Attorney General himself at the Attorney General.
The Act talks about initiate. I don't know why you don't want to understand the word initiate. Initiate doesn't mean that subsequently you should be having meetings with him without his lawyer.
With the greatest respect, Amaliba.
Initiate. Look at the word there.
Let him make his point.
I didn't interject.
No. Isaac, let's go ahead. He won't interject anymore.
I didn't interject because if you take your time to read the entire act, you see that aside even that particular portion, it runs through an accused or the counsel, an accused or the counsel. And Salom, if you read section Rule 40 of LI 2423 that they refer to, this sort of supports the school of thought who've made that argument that the LI 2423 largely refers to lawyers in private practice, not prosecutors per se. Because if you look at Rule 40, it's a special provision for prosecutors. These are the provisions that generally apply to prosecutors. Rule 40 is even titled Special Responsibilities of a Prosecutor, because all the other rules, a lawyer and a client, these ones obviously do not apply to prosecutors. So that's also one school of thought that Councillor Maliba should also take a look at. So if throughout the Act 1079, it says accused person or counsel. In fact, even if you are drafting documents, you can serve it on either the accused person or the counsel in criminal practice. And I believe Councillor Maliba is also very much aware of this. So the Attorney General has submitted or has tendered into evidence several documents upon which the Attorney General closed his case. So the case of prosecution is closed, and any subsequent negotiations that went on were obviously not one that was desirous by the Honorable Attorney General. The case is closed, and I believe the defense ought to be focusing on the defense, how to disprove elements of the offense that have already been established at this point. And out of court maneuverings would not change what is happening in court. So the focus should be what is happening in court.
Very well. Thanks so much, Isaac Wilberforce Mensah, an assistant state attorney and speaks for the Office of the Attorney General as well. So we'll take a short break. When we come back, we will then look at the matter of the SSNIT and sale of hotels and Brian Champon and conflict of interest and all of that. Don't go away. You're welcome back to the big issue. My name is Selom Adonu. Just gone by a discussion on the ambulance procurement trial and how the last court date or attendance turned out with an accused person mentioning or alleging that the Attorney General is being on his case to give evidence that will implicate the accused person, one that's a minority leader, and all of that. So we had Justice Remstrai, private legal practitioner, and Isaac Wilberforce Mensah, spokesperson for the Attorney General's Department, and Abraham Maliba, and of course Franklin Kujo, dealing with the matters. Now we want to go on to another matter that has generated a lot of discussion: the sale of SSNIT hotels. Whether indeed it's a rescue mission as SSNIT is having us believe, or it is state capture, as others to making it appear that why will you sell your 60% stake in 6 prime hotels to a minister of state, a sitting minister of the current regime? What processes were gone through? Were the processes above board? Did the fact that the person was a politically exposed person in the regime play any role? What is the evidence and all of that? Were the hotels underperforming? What were the real reasons and all of that? That is the matter we have before us. So let's watch this clip on the whole thing, on what SSNIT and all of those have been saying about this.
Social Security and National Insurance Trust has come under intense scrutiny for deciding to sell 60% of its stake in some hotels to Rock City Hotel, an establishment owned by Agric Minister Brian Achiampong. Member of Parliament for North Tongue, Okujetu Ablakwa, has even gone further beyond public allegations to petition the Commission on Human Rights and Administrative Justice to investigate the circumstances surrounding the sale of the hotels. Organized labor has waded into the SSNIT conversation, urging the government to immediately halt the sale of SSNIT shares in the hotels. The group alleges that the imminent sale of Labadi Beach Hotel, La Palm Royal Beach Resort, Ridge Royal Hotel and Elmina Beach Resort to the minister amounts to state capture.
Reps and SSNIT board were very clear in their demand that for a number of reasons the process be halted. But from all indications, it appears the process is going on. And in fact, they are even speeding it up. And we don't think that is right. We do not think that the regulations that guide the sale of state assets were followed. We do not think that the necessary due diligence was done. We cannot imagine that state properties will be sold to a minister of state. For us, it smacks of state capture, and that should be stopped, and stopped immediately. And if the Minister for Pensions, who is also Minister for Employment and Labour Relations, fail to stop SSNIT, we workers of Ghana, we own the funds. We will stop that process.
Deputy Secretary General of the Trades Union Congress, Joshua Ansa, argues that the investment guidelines governing SSNIT were not followed in the sale of the hotels.
These funds are not government funds. These funds are pension funds. And pensions are guided by the Act 766. We have investment guidelines under that. under Act 766. And clearly, these guidelines have not been followed. Government should be aware that we will not allow them to play chaskele with our funds. Should they dare go ahead, it will be the mother of all strikes in Ghana.
SSNIT has explained that Brian Achampong's Rock City presented the best technical and financial proposal for the acquisition of these hotels. But organized labor is not convinced. It says due diligence was not done. And even if SSNIT is offloading its shares in these hotels, they should not be sold to a minister of state. Organized labor has therefore requested an emergency.
All right, so Charles Kumi's report on the SSNIT happenings and all of that, what organized labor is saying. Organized labor thinks that the arrangement marks of state capture. That view is very different from what SSNIT themselves think. A lot of issues have been raised about the role of organized labor itself, where they were when all of this was happening, when indeed organized labor has 4 members on the board of SSNIT. How come they did not appear? I mean, the TUC and organized labor generally did not appear to be very much aware of the process until recently, that the Honorable Okujeto Ablakwa, Member of Parliament for North Tongue, petitioned Shraj to investigate the matters of conflict of interest, illegality, etc., in respect of this transaction. The matter really is that SSNIT has decided to offload 60% of its shares in some 6 hotels: La Palm Royal Beach, Labadi Beach, Buzia Beach Resort, Elmina Beach Resort, Ridge, the Trust Lodge Hotel, and the Royal Ridge Hotel, or Ridge Royal Hotel. People have argued that these hotels, a lot of them are doing very well indeed. Labadi Beach doing quite well, very well. Last year, or 2 years ago, paid 23 million cedis to SSNIT as profit. And then the year before paid about 10 million cedis to SSNIT as profit, which means that they are clearly doing well. But SSNIT has argued that they want increased efficiency, more investment for the hotels to be doing better. So they put it out there that they wanted private persons to come in. And according to them, Rock City, which is owned by Minister for Agric, Brian Achampong, gave the best technical and financial proposal in respect of what they want to do with the hotel. And so SSNIT, in letters to minority shareholders in some of those hotels, said that they were inclined to giving the hotels to Royal Rock City. They said Rock City was their preferred purchaser, and that has since not sat well with the minority shareholders, and all these matters have come up. So that is the context of the discussion. Shraj has been seized with the petition. Now, my understanding is that Shraj has responded, acknowledging receipt of the petition, and promised to go ahead and do what it has to do, and all of that. But we also hear that the transaction is still ongoing. It's not been halted. And indeed, people have said that they have seen Brian Achampong and co. at some parts of some of those hotels, at least from Okujeto Ablakwa. The chiefs and some people in those areas have said so. That's the discussion. And Brian Achampong, indeed, has been the gentleman who has been speaking on this matter on behalf of Rock City. His view is that he is 100% shareholder of the company, but he is not an executive director. He says he's a non-executive director, and he did not see how his non-executive directorship will affect or influence anything. That is his thinking, and that's how he's been approaching this whole thing. And he thinks that Rock City is a fully owned Ghanaian company, and Ghanaian companies must be assisted to do well and take up the commanding hearts of the economy, and that's what he's been seeking to do. And his vision is to ensure that Rock City is in every part of the country, and Rock City becomes the place of choice or the hotel of choice. And he's been focused, on doing that. Abraham Aliba, you're a member of Parliament for North Tongue. He's been at this again. Brian Achampong thinks that this amounts to character assassination, damaging his reputation, etc., when indeed he hasn't done anything wrong. Because it's gone through the process. People knew, SSNIT, organized labor, everybody knew that he was the one going to get the deal. Why all of this at this time?
Salom, I actually didn't hear the sale of the La Palm or Labadi Beach Hotel to Brian Champon from Samuel Okudzeto. I actually heard it from an insider. And on one of our conversations, the person told me that, look, he's in the midst of his colleagues in the office, so can we cut the call and he will talk to me later. So I heard about it earlier before Samuel Okudzeto now blew it out. But you see, if you are dealing with or you are saddled with a government that is prone to corrupt practices, and you know about this government, the current administration, when you hear the sale of 4 SSNIT hotels to a minister in the government, you will definitely want to stop and find out whether this doesn't smack of some wrongdoing. The issues here are about conflict of interest, and then engaging in, office of profit. He calls himself what director?
Non-executive.
Non-executive. These are just types of directors. Our company law will tell us that they're just type of that. We have alternate director, we have de facto director, shadow director. You can't use that to obfuscate the issues. A director is a director. And what are you supposed to do? To formulate policies for the company. Now, in his case, it's worse because he's an owner and director. And he keeps running away from the fact that he's the owner. He's an owner and a director. And so, when you vote a group of people into government, they become trustees of state property. You are a lawyer, and you know the duties of a trustee. You are not supposed to benefit from trust property. So, here we are, a minister, and the sale of 6, even though he's buying 4, the sale of 6 SSNIT hotels would definitely, unless we have a useless government, but that would definitely go to cabinet. It would definitely land on the decks of cabinet. Now, if you sit in cabinet, because you're also a cabinet minister, and you sit in cabinet, and these deliberations are ongoing, would you, as a minister of agric, who is also a cabinet minister, deal with the issues on the table dispassionately? You now understand why he says that they will not hand over power.
No, he didn't say they will not hand over power.
They don't hand over power. That's the end. That's the whole essence of what he said. That they were not going to hand over power. If you are a minister and you benefit from a government in this way, why would you want to hand over power? But you see, the Akufo-Addo administration, and I mean the Akufo-Addo himself, when he was being sworn in, said that if you want to make money, you don't make it in my government. You heard that. Now, let's juxtapose what the agric minister has done. He's still not benefiting from in government. What is it that he cannot go and look for land and build those hotels that he wants to spread all over the country?
I said he had the best proposal, financial, technical. And so if it's there and he has the money, why not? His company, not he in person, his company.
But some of the hotels, I'm told, were making profit, or are still making profits, and are giving dividends to government. So it is not like these are distressed companies. In any case, why? Look at Ghana, what was the publishing corporation? They call it, I think publishing corporation, the one at
Assembly Press.
You know, there's this guy there, Asante there. He has revamped the place. But before then, that was a dying company. What does it tell you? It's about who you put there. It is about who you put there. It's not about because the state is the one managing it. This Assembly Press is also managed by the state. But because you put a person with a focus and the ability to turn around the place, that place is being turned around. And so, SSNIT should also know that it is their own doing if they appoint people who cannot manage the place to be there. We saw a letter, and in that letter we saw allowances of the people who manage the place. One of such person was an acting manager of one of the hotels. See the amount of money they were paying to just that individual. Way above what the ordinary Ghanaian receives. So if you are misusing the funds that are coming in, how do you expect the company or the hotel to progress? And I find it difficult to understand why the MPP people who, when they were in the opposition, mounted the moral high ground and spoke about the ills of society will be defending this.
But you see, when Merchant Bank was being sold to Fortis, similar arguments were made, but your side put up a spirited defense. And so we're seeing the same thing. So people say politicians are the same. If you are in government, it's good for you. If you are in opposition, it's bad. And Merchant Bank mainly had Ibrahim Mohammed's issues and all of that at the center of it. And we understand there were people who came with a better proposal, but for some reason went to Fortis, which was being represented by the president's lawyer and all of that. People thought all of those things around the Merchant Bank transaction were not very clean. Yes, still we went ahead with it.
So, and what was the outcome of the people, the verdict of the people when we went for elections? These are some of the things that the Ghanaian doesn't want to be hearing. You don't go back. Are we supposed to be moving forward?
But
at that point, at that time, the government was punished.
So you should end it there.
No, I'm saying that if it were good, the government wouldn't have been punished by then.
But
now, if
solely because of Fortis and UMB,
it's part of it. It's part of it. And if you decide that you are coming to do it better, and we are seeing this, in your case, it's even a minister of state. Look, if state resources or state properties were to be sold out to ministers, how many administrations do we have from the days of Diago de Azambuja to Gordon to Nkrumah to Rawlings and to today? Would those properties be there for Brian Champon, who is just 40-something, 50 years, to be buying a property now? If the ministers at that time, Diago de Azambuja, were buying them through to Nkrumah, would there be anything for him to buy today? And I think that, for me, I believe that we must have a law that prohibits persons who are connected to government from purchasing state property. It stifles the initiatives of those institutions wanting to, as it were, revamp the place. This may be a good deal, maybe to revamp the place, but did it go to the right person? And has any laws been breached? And I'm thinking that conflict of interest would arise here because he's a minister of state. I think that he has been told, the constitution says that you cannot engage in office of profit. He's done those things. Those are the things we are talking about. If you have, say, a deal and I am bidding, you are also bidding, then the minister is bidding, clearly the minister will have an upper hand over the two of us. And that is what I think that should not be allowed. There must be a law. I'm calling for a law that will prohibit ministers of state, persons connected of government, from purchasing state properties.
Very well. Let me speak to Mary Ada, who is Executive Director for the Ghana Integrity Initiative. Hello, good morning, ma'am. Welcome to The Big Issue. The Ghana Integrity Initiative is not been so happy about the current transaction. What is the basis of your unhappiness with this particular transaction?
Wow, there is so much echo in here, so I can't hear you.
Apologies. I'll get my team to work on that. So whilst we are at it, my team will work on that. So we will connect with you again. So we hear what you have to say. My technical team is working on that. Let me speak to Franklin. Franklin, civil society has been quite consistent on matters like this. But what are the matters that jump out to you in this particular transaction? This is a Ghanaian. It's a fully owned Ghanaian company. Of course, it's a minister of state and all of that. What stands out or jumps at you in respect of this particular transaction, given the fact that we want to support local industry or local companies to become world-class?
Look, this matter, I'm a bit ambivalent here on this one as well, because I know the long history of SSNIT, and I think we need to be we need to step back a bit and ask ourselves a few questions. SSNIT is divesting itself, divesting these assets because perennially, if not annually, we've not been managing them well. And please, this conversation about when you change management, you keep getting the same thing over and over and again. A friend of mine, I did land economy, and we do valuation as well. And so a friend of mine, a mate of mine actually, told me, and I think I shared this publicly. He's been part of the valuation team, actually his firm was valuing SSNIT for the past 5 years. And most of their hotels are doing next to zero, virtually nothing. Now, if I had my money, if it were my own money, I probably wouldn't even be buying those things for the amount of money that is being bandied about. I would not, because some of the valuation things I've seen, I don't know what Brian and Co actually see, but maybe they see something else. But frankly speaking, we've run down, politicians have made SSNIT the likes of NIB. NIB is getting 2.3 billion cedis with an MD who is running for parliament. An entity that has not returned a single cedi dollar since 2013 is being resuscitated, recapitalized with 2.3 billion. That's what we do to our state institutions. And SIGA is sitting there also funding the thing, clapping in unison. Look, SSNIT has perennially been pillaged, if not raped. You recall that through Imani's efforts, the second tier funds had to be transferred. It was a battle about how many years ago? Forgotten how many years this was. I'm sure you were in this country. We fought hard. Basically, the Act 766 came to being, but to get even SSNIT, or to get the state at the time to give back this 5.6 or is it 5% or 5.5% of pensions money or contributors' money to the trustees, which are the corporate trustees, for the second tier to come into operation was not easy, right? Now ask yourself, why did the country decide that we were going to reduce SSNIT's reduce SSNIT's share of
shareholding
of worker pensions? Why did the state do that? Why did the country do that? Well, we realized that perennially SSNIT was not being managed well. This is not the first time we are hearing about SSNIT involved in all kinds of things. Most of the assets are returning next to nothing to the state. And in fact, I was happy when I heard not long ago that they want to divert themselves out of real estate because, frankly speaking, it's become like the politicians' piggy bank. They do all kinds of things with it and then turn around. SSNIT is, if you look at in terms of how much we've spent on the management and the administration, it's just too much, right? So for me, frankly speaking, I was happy and I heard that they were going to divert this hotel. So I mean, originally I'm averse to basically state entity, especially in Africa, where you have all these vampire politicians sitting at the helm there, playing chess with our money. Basically, having a state country like Ghana or African countries actually running state entities. They never return anything. Zero, zilch. That's what they return. And so for me, I was happy when I heard that this was happening. Look, I'm looking at value, and that's me. Which you talk about, and I think others are talking about the issue of conflict of interest. Brian should answer the questions concerning conflict of interest, where he got the money from, which is one of the things that has come up as well. Well, of course, that in itself has to be discussed properly because I think the gentleman has been running businesses for a while now. But it's also good to ask this question because he's a minister of state and is really well placed to get favored information, as has been the case. But beyond anything else concerning all of those, conflict of interest and all of that, I am looking at the issue at stake. I mean, the real issue at stake, where we are losing money consistently as a country. I don't want to use my 13% money to be continuously funding somebody's how do you call it, pet project. So a politician can do anything they want anytime they wake up. You have no idea. The dossier I have on SSNIT, way before this current administration came to power, and even as this administration is in power, I think the current administration, the gentleman who was unceremoniously asked, Dr. Tinkren, I mean, a world-class human being, really, and I think he's done so well. I was happy when eventually the government wrote the papers, basically issued a paper saying that he's done no wrong. Look, I am telling you that the things I've seen, the long relationship with SSNIT, I'm happy for SSNIT to divest of these things quickly. They should do it. And I think the values that are at stake, and I don't know nobody's even talking about the values. Has anybody come out to say that whoever offered whatever money was being offered, the 96 million for capex and all of that, is wrong? I don't think we've gone there yet. I think Kujato's issue really has to do with conflict of interest and the fact that the guy is also a sitting MP and all of that, which must be dealt with. But on this one, I come from the angle of somebody who has seen how a state entity can be pillaged. And so people should also be interested in making sure that we cut off politicians' arms at once from these pillaging acts. And I think that's where I see it. I frankly, my real conversation, I think the real conversation is not being had. And I don't, and it's no joke. I think the real conversation is not being had. Even these issues about conflict of interest, was it lawyer, the current rector of UPSC, who has suggested that it's a bit nuanced. You need to be cautious. You're a lawyer, you probably know this. But those conversations must be had. Did Brian have prior knowledge? Did he know about this sale? Because there's also insider dealing and insider information that must be looked at. I am just sitting on, I've spoken to my fellow valuers, and that story they tell me, the guy said for 5 years. In fact, at a point, SSNIT was even giving him, he and his wife, what's called family, sometimes they stay there for free because they do work in return and all of that. But it got to a point, the family said, no, they can't sit and sleep in this hotel. And every year they come, I see Almina Beach, the place is just run down, and they're running stuff down. I mean, you've had all kinds of conversations concerning, well, I had Labadi return a certain profit last year, last year. But that's just a single year. You should go back and look at what is happening there. So frankly, the politician involved in this matters, Charlie, I don't want to see any politician have a hand in some of these running.
No, but frankly, for example, Abraham Maliba makes a point about Assembly Press, the Ghana Publishing Company, etc. The place was almost dead, but we see David Asante there doing quite some good job. I go there quite often to buy, laws, etc. Doing quite some good job. So it's an issue of leadership.
The Assembly Press, I understand the issue of leadership. The Assembly Press doesn't really.
It's not a good example.
It doesn't see money on a daily basis or on a monthly basis like SSNIT does. I'm not saying that it's not a good example. It is, but look, anywhere you've seen political entrepreneurs being virtually, politicians being asked to man stuff, or politicians having a hand or overseeing state entities, it's always been run down. Look at what even happened in South Africa. We have all this thing called black entrepreneurs. Now they've virtually run the corrupt, made the country entirely a corrupt entity. I am not happy, and for my position on government involvement in some of these institutions in a way, and on that basis alone, the figures I've seen and the reasons why we decided to divest, reduce SSNIT's exposure or reduce the pensioners' exposure to SSNIT's behavior, I think it still falls in line. So let's bring back the conversation. We can have the conversation about conflict of interest. When we finished, let's not talk about the values. Nobody is talking about that. The values that are, and I think it is fair, really, to talk about it.
Very well.
Right.
So Franklin says we should have the conversation about conflict of interest. When we are done, we should have the conversation about the values. Talking about conflict of interest conversation, I earlier had a conversation with Kojo Asante, who is a director at CDD, and he had a few things to say about this matter of conflict of interest. So I'm taking you to that discussion. We'll come back and then we'll continue the discussion. Hi, good morning, Doc. Welcome to The Big Issue. Just want to find out what your initial thoughts will be on this whole arrangement by SSNIT to offload 60% of its shares in some 6 strategic hotels to a private investor. I mean, what's your initial thoughts on the arrangement before we delve into the matters proper?
Well, I think it came as a surprise to many. Of course, I got to hear about it when the MP for Tong, South Tong. Is it not Tong or South Tong? Mr. Blakwa, Petition Raj to look into the matter. So I think, and then to find out that these negotiations and engagement has been going on for quite a while. I think immediately one begins to question why SSNIT would decide to divest its interest in some of the hotels that have been listed for the transaction, particularly Labadi Beach Hotel, which everybody knows is a profitable business and one of the best hotels that we have in the country. If you own 100% of a business and it's making you money, why would you want to divest 60% of your shares out of it? So that, I think that was curious, and because we don't have as much information about the transaction, what led SSNIT to make this case, what kinds of information did they rely on to make a decision? I think we want to know more. I think that's definitely one issue. I think it's also the same issue that I think organized labor is also interested in, and then we can talk about organized labor and their representation as well. But the other big issue, of course, is the conflict of interest situation that arises because the company involved is owned by current sitting Minister of State, who is also a member of Parliament and also a leading member of the ruling party. So it immediately triggers, Article 284 of the Constitution, where public officers are basically, not supposed to put themselves in a position of conflict where they can, conflate their private gain with the public interest. And once that potential conflict of interest arises, then we have to scrutinize any processes that is involved. If you are a member of government and you are going to transact business with the states, immediately we have to bring a layer of scrutiny to that transaction to make sure that it's not your private gain that we prosecute, but it is the public interest that we prosecute. So all of those circumstances require that we need to understand how SSNIT has dealt with that conflict of interest situation all throughout this transaction to make sure that it is a fair deal for anybody that it is participating in this transaction.
Very well. Persons, of course, many have said that because the minister in question, Brandy Champon, owns the purchasing hotel or company, Rock City, that even makes the situation murkier, and you've alluded to that as well. But there's also the principle of the separate identity or personality of the two individuals involved, or the personalities. The company as in having its own legal personality, and the person of Brandy Champon being a natural person. Is it not for reasons of this nature that we have by law separated the company from the natural person, so that the company run by its directors and management will go ahead and make decisions based on what they think is right? So we take out the personality of the natural persons, in this case, Brandy Champon, from the equation. Does it help any matter?
Yes, I mean it is. Yeah, and it is important corporate principle that the company is a separate legal personality from its members. But in this case, you have to basically remove the veil, because the person that is involved is the sole shareholder, but not just the sole shareholder, is the sole beneficial owner. Everything that the company does, the profits that it makes, comes to this person. So that in that case, you cannot escape Article 284, because in his position, in his personal position, he is a public officer. And if he is transacting business with the state, he stands to benefit privately, but at the same time, he is also supposed to pursue the public interest. or at least SSNIT is supposed to pursue the public interest in this case. So SSNIT has to make sure his particular presence in this transaction does not influence SSNIT in any ways that make the transaction unfair to others. Right? So it's not enough that his company, and with conflict of interest situations like that, normally, if you really want, particularly when you're going to serve in public service and you really want to separate yourself from the business, you normally put the business in a blind trust, where completely you sort of remove yourself from any operations of the organization. But I mean, the fact that he himself even has been representing the company in this discussion, suggests that that's not been done. He's not sought even permission from the speaker to operate, this Office of Profits, which the Constitution also, frowns upon. So there are many, many things that shows that there's apparent conflict of interest. The question, as I said, is how is that conflict of interest being cured by SSNIT, which is the carrying out the transaction, just to make sure that anybody who bidded got. I mean, this is the person also who sits in cabinet. So in that type of influence, and it's the state that's making this decision. The board members are appointed by the president, so you have to just apply a certain layer of scrutiny to make sure that it's a fair deal, because the only way the state benefits if it's open, competitive, it's credible, transparent, and we get the best value for money.
Others have said that.
And I think that's the condition you have to do. Yeah.
Very well. Others have said that at the time, he won the bid, for want of a better phrase, he was not a Minister of State. He became a Minister of State sometime last year or the year before, when SSNIT, from the correspondences we've seen, had described him, or he's described Rock City as a preferred purchaser or company to own the shares or to have the shares transferred to them. So at the time the transaction or the decision was made on his company, he was not a Minister of State. Does that count for anything?
Oh, no. I mean, as I've read to you in Article 284, it talks about a public officer. He was a member of parliament at that time. He was a former national security coordinator, national security advisor.
National security minister of state, I think.
Yeah, that's right. I think he was the national security advisor before, and then he was made a minister of state. He even went to interior at some point. So, and then I've mentioned the fact that he's also a politically exposed person, because he's a leading member of the ruling party. So he has influence and access. The people that he's competing with don't necessarily have those kinds of things. So that definitely raises questions of conflict of interest, even if he was not a minister of state. But even as the transaction is subsisting, he becomes a minister of state, and that adds to the situation. As long as the transaction is proceeding and all of that, then, because even if you have been selected and there has to be negotiated processes and so on and so forth, influence, if it's still subsisting, can affect the credibility of the transaction. So you have to look at the entire value chain of the transaction to understand that it's clean, it's above board, it's pursue the public interest, and therefore we can go for it. But I think, as I've said, the matter of why SSNIT is making this decision to divest its interest itself is one that has to be interrogated, and I'm happy that Labour has taken that up, and we hope that we'll get more light thrown on that matter as well.
So finally, what would you think, or what would your suggestion be, given where we are now, The process has not been halted. The process is still continuing. And from what Dr. Ablakwa tells us, the process may conclude anytime soon. What do you tell SSNIT? What do you tell Shraj? And what do you tell the parties involved?
No, I mean, I think the process has to be halted. The matters that have been raised are very serious. And you know, when the Citizen Coalition had its press conference this week, one of the things we raised is that the profitability of state-owned enterprises is one of the things that have been flagged in the IMF program as one area where, you know, government has to do a lot more in tackling. And, you know, when you have assets that are working in your favor, one will wonder why you want to divest of those assets. And I mean, in this economy, you ask yourself, okay, if you even get the money, what are you investing in? Because it's a very difficult economy. So, you know, it's I mean, you don't want to speculate. So you want to see what kinds of analysis that has been presented to the board of SSNIT for them to make this decision. You know, people have raised the question, is somebody, if you are a member of government, are you entitled to access or buy state assets? And people find that as immoral. But I think that the most important thing that we have to pay attention to is that, yes, even if that's the case, that, you know, government decides to divest, you know, itself of its interest in an asset, the people who are competing to buy it, is there fair competition? Are they given an equal chance? Is somebody not being favored? You know, these are the things that we need to establish, you know, and the principles that govern that is one of the reasons why we are pushing so hard for the passage of the Conduct of Public Officers bill, because that will codify very clearly all these public ethics issues around conflict of interest, asset declaration, influence peddling, nepotism, and even unexplained wealth. You know, so we can really tie up these loose ends, because every issue around corruption that you examine, it starts with these relationships that are not properly regulated.
Very well.
And people say, well, you know, it's not properly codified, so I haven't done anything wrong, you know. So I think we need to get to that point. Yeah.
Thank you so much, Kojo. We're so grateful that you made time to speak to us. Thank you so much for your time.
You're welcome. You're welcome.
Thank you. All right, so that was an interview I had earlier this morning with Kojo Pumpuni Asante, Director of Advocacy and Policy Engagement at the Center for the Democratic Development, the CDD. And the CDD have always been big on conflict of interest and matters like that, so we deemed it appropriate to speak to him, and of course he made his points quite clear. Abraham, I don't know what you make of the responses by Kojo Asante of the CDD in respect of the conflict of interest matters. I think generally the same views as you have.
I think he's spot on, and I noticed that you tried to distinguish between the time he wasn't a minister and the time that he became a minister, and the transaction took place at the time he wasn't a minister. That was a clever distinction, but I think that he was able to, as it were, hammer on the fact that he wields a lot of weight in the administration. Apart from the fact that he's now a minister of agri, but his previous life as minister for other sectors of the economy makes him have access to collect ministers who are sitting in cabinet. So he could also use that to influence the decision in cabinet. So no matter how you look at it, it is so murky, it is, as it were, unacceptable in corporate governance for such to happen. And even where you have good governance in an administration, one would have thought that immediately they saw his bid, that alone, the fact that he's a minister, should have disqualified him. in very serious democracies,
but
this would have been
disqualified. Wouldn't that be unfair if you talk about the procedure being stringent and raising the bar a bit and all of that? That's fine. But to disqualify him when indeed it's not his person, it's a company he has shares in, that will be unfair to the company, won't it?
And I think you raised the same question, and Asante indicated that, look, these are the type of cases that the corporate veil is normally lifted. Yes, a company is distinct from its owners and the officers as well, but in some cases, you have to lift the veil to know who is behind the company. And so when you do that, you will see that it is a trustee who is supposed to protect these properties, who is supposed to superintend the proper utilization of the properties, who is behind the purchase and sale. So it is not good for Brian Champman. If the sale has already gone through, as I'm hearing, I think it should be halted, but it should be abrogated rather, and if it is still going through, then it should be halted. I think it is not good, and I have said that if other ministers before him were purchasing state properties, he is not the one who would have been buying this property today.
I see. Franklin, of course, you are for private sector development and all of that. I don't know how this sounds with your private sector orientation, that he's a minister of state but owns a company in the private sector that is buying this. I'm also for local company growth and development, etc., to take up the commanding heights of the economy. But given this context, what do you think could have been done better to avoid all of these things we are seeing? Of course, I recognize your first point you made about your ambivalence, the value and all of that, but what could we have done better to ensure that we didn't see this? Or you think it would have happened anyway, given the political exposure of the person in question?
Let me answer this question probably in two ways. First of all, if I'm on the board of SSNIT and given all the information that they have, and they decided that they want to divest the staff they are looking at value, right? So they put out bids and they put out an advert all the way internationally, and narrowed down to about 4 or 5 companies. The highest bidder suggested 96 million. The second one 65 million, and the third 48 million. With that, I'm thinking 96 is my gig, and I'm probably going for it. Now, the other thing SSNIT should have done, as they got all the bids, and they found out that, Rock City obviously belongs to a politician, they must have also done all their due diligence and actually find out whether the minister was still in charge, essentially whether he's created a blind trust or something like that, so that there's no connection necessarily between him and the company. I mean, these things are normal. It's easier to do, right? And so those questions should have been asked again at that time. I don't know if SSNIT did that. They need to tell us. SSNIT needs to tell us exactly what really happened in that regard. Even though they were eyeing the money, they should have also considered the fact that the person buying or the company buying was connected to a person who is politically exposed. And it's important that issue is actually dealt with, because in this part of our world, yes, it's a crucial matter. Not just here, internationally as well. But I think for me, it looks to me that SSNIT was pretty much interested in the money, and obviously getting itself out of this trouble with people just having a go at them anytime they wanted. So yes, the SSNIT should have asked those questions, and I still think they should tell us whether they did or they did not. And let's know whether Brian indeed was still connected to the company as at the time all these things were happening. I think it's important to get to know that. So for me, I have no quarrels with that at all. I'm only just worried that, again, some of the things we normally talk about, mostly in this town, things will be done well, and then they never get done. As long as it's long about the state, I would have wished really that SSNIT didn't get even 10% of workers' money to do anything, right? They should probably get above that. They should be getting the 5%, and the private entities, well managed, should be getting the other one. Consistently, SNIT investments have shown not to be really, they have shown to be subpar, right? The returns have been basically have been subpar. So for me, anything they will do in order to take themselves out of all these little pies, which is just giving them trouble, well, why not? Well, even the so-called hotel that was returning profit, you never know how some politicians probably were eyeing it, and all kinds of things could be happening. But I certainly, the question about value, what's it called, conflict of interest ought to be looked at. And I think we are overly focused there too much. Because let's all, truth be told, I don't think Branch has been seen to have stolen anybody's money. I don't think that is even in contention. Now people are asking the source of money. Yes, you should know that, but we also know he's been in business before, and which is why I'm thinking that we should ask those questions. But at the same time, let's get to the value question, because after this conversation about conflict of interest, we need to come back to the value question. What about the other two bidders who put in lower bids? Right? Nobody's talking about them. There's so many things I heard about, even one or two of the bidders that I don't want to put out there, because again, I feel because it fits into all this politicization of the issues. So please, let's go ahead and talk about the conflict of interest, but let's also look at the monetary aspect of this, because workers' money cannot just be. In fact, the other question we should be asking ourselves: if these things are divested and the money goes back to the SNIT, putting the money back into the chest for workers, that's what they should do. And I think those are the things I'm really concerned about. Rather than spend workers' money, almost $1 million every month to prop up these entities, why should we be doing that? I think it's just bleeding money. Just yank it off. So I'm quite bullish on that, really. But we should ask the questions about value, what's conflict of interest. But let's look at the value and ask were the fair values being given. And the other two companies have nobody has come out to protest that, we were cheated. And no. I don't think that's what has happened. Right.
Organized labor has said that they will stop the sale of the shares in the 4 hotels to Brian Champon. Right. Of course, an organized labor too is being represented, on the board of the SNIT. Does their position now surprise you, given that they should have known that this was what was happening before the Honorable Kujato Ablakwa, brought this up? And so people may say that their position is quite belated. Do you share that view? Since they had 4 members on the board.
Well, it is concerning that if you have 4 members organized labor, knowing how prosperous organized labor is, I'm surprised that the frontline handlers of the organized labor like TUC did not know about this. I'll be really surprised. What were those 4 representing? Who were they representing? They were representing the worker front anyway, and I'm so shocked that there will be this strange, gulf between the representatives on the board and then the core membership of organized labor. I'm a bit worried, and I think if that comes, we should really pursue that course as action. We should ask the representatives themselves whether they did inform the larger membership. We should ask them questions. It's important. And I think the other thing we also need to find out exactly is, if there was a proper investment plan attached to this particular enterprise, and how it's decided that they were going to divest this particular 4 hotels off. I think we need to know all of that so that it helps the conversation. Because if we don't have all of those, I certainly think it fits a lot. It fits into the narrative that something grand untoward must have been done. As we speak right now, the real concerning issues right now in the public domain about a minister who must have purchased a property belonging to the state. We need to deal with that, but I'm looking again at a wasting asset, a wasting state entity that is constantly using your money to do things that are not serious, that are not sensible, and wasting that money. So it's better they stop that pillaging, and then whoever gets the investment buys it, and then look, we are done with that, really.
I see. So, Honorable Amaliba, like you said, it's quite concerning. organized labor is been screaming they will halt the sale or they will not agree, etc. The SSNIT law must be changed, etc. But there are 4 representatives of organized labor on that board. All right, let me speak to Honorable Samuel Okudzeto-Ablakwa, who has just joined to make a brief intervention, and I'll come back to you, Amaliba. Honorable, good morning. Welcome to the program. Can you confirm to us, first of all, whether SSRAJ has acknowledged receipt of your petition and what the next steps will be from here? Honorable Okudzeto-Ablakwa. Hello. Yes. Yes.
Hello. Can you hear me?
Yes, I can hear you. I'm just trying to find out from you, or getting you to confirm to us whether indeed SSRAJ is responded to your petition and what the next steps will be from here.
Yeah. Good morning. I can confirm that SSRAJ has acknowledged the complaint I filed on the 17th of May. SSRAJ on the 20th of May, on Monday, promptly wrote to me indicating that they are in full receipt of the complaint and that they are about to commence investigations and that they will revert in due course. And so I should hold myself in readiness. So I can confirm to you that on the 20th, I received a response from SSRAJ, signed by the principal registrar of SSRAJ on behalf of the commissioner, indicating that they have received the petition and that they will be contacting me shortly. So that's where we are as regards the complaint I filed last week.
Okay. Did they give any indication about timelines, given the urgency with which you prayed them to handle this matter?
They didn't state that specifically, but I want to be hopeful considering how promptly they have acknowledged the complaint and how they have promptly asked that I hold myself in readiness. I want to believe that the grounds upon which I came, as you have rightly indicated, I stated that time is of the essence because the SSNIT is in the final stages about to finalize this deal and hand over the hotels to the Honorable Brian Champon's Rock City. And the latest documentation I have is that all of these hotels have been written to by both the transaction advisors, Sem Capital and Rock City, that they should submit all documentation in their possession, their financials, legal documents, their property status, and they themselves as managers of these hotels should avail themselves to Rock City because they are conducting final due diligence ahead of their takeover. So these latest intercepted documents prove that if we do not get a certain urgent investigation from SSRAJ, if SSRAJ does not expedite action on this specific petition, it may just be too late. Because remember that already organized labor at their press conference said that their reps on the board told the management of SSNIT to hold on with the transaction. And yet, my oversight work I have conducted reveals that the management of SSNIT did not listen to organized labor, and they have proceeded in earnest to continue with this deal and to seek to finalize it. So time is of the essence, and I do hope that my prayer to SSRAJ to expedite action will indeed materialize, and that SSRAJ will recognize that time is of essence in this matter. Unfortunately, under the SSRAJ law, SSRAJ does not have the power to injunct. But in terms of good governance, I hope that as Shraj writes to all the parties to submit themselves to this investigation, that itself, if SSNIT is minded, if they have nothing to hide, if they want to show respect to Ghanaian workers, to the Ghanaian people, to Parliament, then they ought to really stay their hands and fully cooperate to the investigations and hold on with finalizing the deal. I mean, that is what people who have respect for the people they serve. Remember that sovereignty resides in the people. SSNIT does not work with their own money. They work with our contributions, workers' contributions. And if the people who you represent, workers, whose contributions you are using for these investments and taking these decisions, which clearly are not in the national interest, you need to show them respect by holding on and allowing for these investigations to be concluded. So I do hope that SSNIT will not, as it were, undermine the investigations and take the Ghanaian people, organized labor, and all the civil society organizations that have risen against this deal. I hope SSNIT will not take us for granted and act in a contemptuous manner.
Yes, so that's on one leg. SSNIT themselves thinking or seeing this deal to be good without an external force stopping them, they go ahead and do it. I'm not sure there'll be anything wrong with that legally. Does Shraj have what it takes to halt or ask them to halt the process in the meantime?
Yes, I believe in the meantime, Shraj can say that, look, we are conducting investigations. Any conduct at this point could undermine our work. So even though we don't have the power to injunct, we can advise you to allow the investigative process to proceed. Don't do anything that undermines the investigations. Because if we are investigating, if you look at the petition carefully, I've raised issues about conflict of interest. I've raised issues about violations of Article 78.3 and Article 98.2, which means that the Honorable Brian Champon had no business going near this transaction once he didn't have certificate from the Speaker to engage in an office of profit or to do business. The Constitution is very clear because of conflict of interest. And he has confirmed this week in a radio interview that, yes, he has not applied because, as I indicated to Shraj, I had done my due diligence, written to the clerk, to the committee on members holding office of profit. They have submitted to me all 47 names of MPs and ministers who have complied with Article 78 and 98 of the Constitution. The Honorable Brian Champon's name is not there. He has not complied. He doesn't have a certificate from the Speaker. So he had no business going near this transaction. I have also indicated that there's been considerable arm twisting. If you look at the 10th May 2024 letter written by the lawyers of the minority shareholders at Ridge Royale, they state in clear detail that the shareholders agreement of 1st April 1999 has been violently violated, and that SSNIT ought not to have gone ahead to advertise and to procure when they haven't called a general meeting, a shareholders meeting, and to have a shareholders agreement on how to proceed with the shares. Remember that the minority shareholders had the first right. So there are so many instances of procurement breaches. If you take, for example, what was advertised on 7 February 2022 on the SSNIT website, you say you are organizing a procurement process for the sale of 6 hotels. How does it become 4 midway down the lane? What the procurement law warrants is that once you are changing the object, the principle, what is being procured, you must start afresh. There has to be a retender. They didn't do that. So constitutional violations, breaches of the procurement law, disregard for due process, disregard for the shareholders agreement, and then even how SSNIT is treating all these hotels as if they are in the same status, as if they have the same financials, as if they have the same share structure. I mean, it's bizarre. So there's so many fundamental issues that we are raising, and it is imperative that SSNIT holds on so that these investigations are concluded. Shraj makes a definite pronouncement, and then we can see our way clear.
Very well. Thanks so much, the Honorable Samuel Okudzeto-Ablakwa. Thanks so much for speaking to us and bringing us this perspective on the matters. We are grateful. Let's do a quick one too with Emmanuel Owusu, who is Executive Director of Crusaders Against Corruption, and we'll come back in studio and conclude with Abraham Maliba. Okay, so I understand we just lost him. So Abraham, so we
you were talking about the membership,
yes,
of organized labor.
Organized labor and how they are
I've
now.
sat on boards before. It's sometimes you have good ideas coming from a minority group, but when it comes to the decision making, they will be outvoted or outnumbered. I'm told there are 4, but when you look at the entire membership,
About
it's
12?
9. Is it
Okay.
9? Yeah.
I think there are about 12.
12.
And okay, they are 9.
They are 9, yes. And when you look at those
no, they are not 9. There are 4. So, for example, 1 chairperson, 2 nominated by the president, 2 representatives of Ghana Labour Employers Association, 4 representatives of organized labor, 1 rep from the Pensioners Association, 1 rep from the Ministry of Finance. 1 rep from the Social Security Services, and then Director General of Trust, and a company secretary.
When you look at it, those coming from the government sector are more than, I'm not talking about those appointed by the president, but those coming from the government sector are definitely more than the trade union people. So, and I'm told that they opposed it. They raised the issue. The 4 refused to go with the rest, but they were outnumbered. So I just think that they didn't come out early, or they didn't raise the alarms before even Okudzeto came in, because they knew this was happening. And my understanding was that they were trying to engage behind the scenes, but you don't do this type of things.
The organized labor and the way they've come out to speak appeared they were in the dark. Then it means the guys on the board might not have been engaging their principals.
Sometimes it happens. They just sit on the board thinking that they are there on their own. They forget that they are representing people. But my understanding is that when you look at the minutes, the 4 actually opposed the sale, but they were outnumbered. As to whether they kept relaying the information to which they were supposed to do to their superiors, I don't know. I also heard that they tried to engage the president. They've sent a letter now to see whether they can have audience with the president and the chief of staff. Let's see what comes out of it anyway.
I see. Frankly, I don't know whether the comments from the Honorable Okudzeto-Ablakwa, have raised any further issues in your mind in respect of how the transaction doesn't appear to be halted now that Shraj has entered the fray.
Well, I think what will be useful will be for SSNIT to serve the public as well as whatever they send to Shraj. We should know everything that has happened around this thing. It's very, very important that we know. And I think the other questions that are being raised also ought to be answered. I seriously think they should be answered. I'm glad that nobody has questioned the values that have been put so far, and that's where I sit. And for me, I think, clearly speaking, those stuff must go. It just must go. I don't believe in this forever, a year management. Never happens. It's like politicians. They come into power, they start the personal project. By the time they are finishing power, leaving power, the other set is waiting to come and do the same thing. We are tired of these kinds of things. Start the bloody stuff up, please. They're wasting everybody's time.
All right, let's speak to Emmanuel Wilson, who is Executive Director at the Crusaders Against Corruption. Good morning. Welcome to the program. The anti-corruption civil society organizations have raised some issues against this particular deal. What is the basis for the opposition of the anti-corruption people, inclusive of the Crusaders Against Corruption? What is your basis of your opposition against this arrangement?
Well, thank you, Salom, and good morning to your viewers and listeners. This whole transaction raises or suggests some level of corruption if we are not able to get the transparency of it clearly. There are two issues that we are considering, and one has to do with whether or not there is a purported conflict of interest. The other one, which we all know to be the basic definition of corruption, having to do with using one's position as an advantage to benefit himself or his cronies. That amounts to corruption. And so the issue of Brian, vis-a-vis that of SSNIT, what we are wondering is whether or not we can establish any of these two things. Has there been any purported conflict of interest? Is there any issue that has to do with, but for his position, but for his relevance in the political space, would his company have been given this opportunity? SSNIT has been a bit quiet on letting us know the procedure in which they arrived at getting Danny Champon and his company to take up these 2 or 3, I think it's about 3 or so.
About 4.
Hotels, 4 hotels. So we want to know, and for us, till these things are established, it will be difficult for us to say that this has been a transparent transaction, and we want to agree that, or assume that this borders a bit on corruption.
I see. So, is it a case that because Brian is a politically exposed person, that alone is what it is for you, or you want to go behind and see if the processes were followed to the letter? So if the processes were followed to the letter, SSNIT comes out to say so, would you be satisfied that indeed, even though he's a politically exposed person, the scrutiny they gave his bid was above board, which is really what the case should be? Would you have been satisfied by that?
It is largely about the process, because transparency is key when it comes to fighting corruption. And so we want to know how the process took place. Was there anything known as open tender? If there was, we want to know the other companies that went through it. And if indeed other companies went through it, we also want to know on what basis Brian stood tall above the other companies, and why SSNIT decided at the end of the day it is Brian that should be given. We want to be clear in our minds that indeed there wasn't any influence on SSNIT just because Brian holds a political position or political influence. And these are the things that bothers us. So far, unfortunately, SSNIT has not been able to convince us that there has been some level of transparency. SSNIT has not been able to convince us that, but for Brian holding a political position or being politically exposed, he wouldn't have been given this position. These are the basic things that we intend or we wish that SSNIT will address. And that is why our focus is largely not necessarily on the ground that Brian has been given. Whether we like it or not, Brian is a Ghanaian. And so if he deserves it legally, why not? We support it. But in us ensuring that he deserves it, he is a Ghanaian, we must not throw away the fact that we will not condone anything that borders on corruption. And that is why we want the procedure to be clearly exhibited for everyone to be convinced. Is it also a case, talking about purported conflict of interest, is this also a case that Brian has sought permission from Parliament in engaging in this kind of business? These are the things that we need to know. And unfortunately, as I indicated earlier, SSNIT has not been able to convince us on this line.
I see. Thanks so much, Emmanuel Wilson, Executive Director and Chief Crusader, indeed, of the Crusaders Against Corruption. Thanks so much for speaking to us this morning. Yes, gentlemen, just to take your concluding remarks on this, let me start off with you, Abraham Amaliba. What would be your concluding remarks on this whole brouhaha?
That this transaction is not above board, and that the workers of this country have been shortchanged. We also think that there is no need for government officials to profit from state property. And at the end of the day, I am of the view that just as how the workers have indicated, I want to support their call for an end to the transaction. If already Brian Champon has paid monies and is in control, this transaction is tainted by a number of, if you want, wrongdoings, issues about corruption, issues about conflict of interest, and the fact that the Constitution does not allow him to engage in office of profit. Based on these three, I am of the view that the whole transaction should be abrogated and his money given back to him. And then SSNIT can start a new process without interference from government officials.
I see, but like Franklin says, nobody has really raised an issue with the value. There were two other people with lower bids, and they can only work with what they have.
No, we should be guided by principles in this country, and we cannot say that because the value is good and that he has paid good money for the 4 hotels, we can allow politicians who have influence and have access to continue acquiring properties of state. Look, if this continues, one day our children will get up and say that some of us were lazy people. When indeed I'm a hard-working Ghanaian, but because I wasn't in government, I couldn't acquire those properties.
I see. Very well. Franklin, your concluding remarks on this whole discussion.
Right. Well, I think it is fair to ask questions concerning conflict of interest. Never mind that I don't think Brian came into this conversation simply because he was Brian, but I think he also owned a hotel, and I think that is also that must be considered, because I don't think he just jumped and then decided to buy these hotels. Whatever it is, we need to know whether he's at arm's length with his Rock City, because those things are required while he's in public office, and it's important that we get to the bottom of that. So he should give us all that information, and he, Brian himself, should be able to give us those information. But as far as value goes, and as I've seen the values, the other 2 competitors were bidded, they have not complained at all, and the value as it is now, I think it's a fair value, seriously, given what I know with SSNIT investments. Thank you.
Very well. Thanks so much, Franklin Kudjo. Thank you so much, Abraham Amaliba. Thanks so much to all our guests who joined us on this segment of the program. We are happy that you made time to join us today. My name is Selom Adonu. Catch you same time next week for another exciting edition of The Big Issue.